You will address this court with respect, or I will hold you in contempt before your case number is even read. The gavel came down once, sharp, final. The sound bounced off wood-paneled walls and settled into the silence like a slap no one could return. The woman at the defense table did not flinch, did not shift her weight, did not look at the public defender beside her, who had already begun sweating through the collar of his off-the-rack shirt. She stood with her hands flat on the table's surface, fingers spread, palms down. A posture that looked like submission, but was something else entirely. Her eyes stayed level with the judge's chin. Not defiant, not deferential, calibrated. Judge Clement Braxton leaned forward from the bench, his reading glasses catching the overhead fluorescence and throwing twin discs of light across his face. 22 years on this bench had carved permanent lines of authority into his expression. He had a way of looking at certain defendants, not all defendants, just certain ones, as though they had already been convicted and were simply wasting his morning by existing in his courtroom. He was looking at her that way now. Dispatch IDH 4471, 14:22 hours, October 7th. The narrator would later read from the official record. Caller reports black female trespassing on private property adjacent to Linden Road. No weapon observed, no threat described. Caller identified as property owner, Kirk Oakley. The caller was the arresting deputy. The woman he arrested was standing 6 feet from his witness chair right now, and he had not looked at her once since entering the courtroom. How does the defendant plead? Braxton's voice dropped into that registered judges use when patience is a performance rather than a practice. Not guilty. 2 words, spoken without inflection, without plea, without the tremor that Braxton's courtroom had been engineered, through decades of procedural intimidation, selective scheduling, and the quiet architecture of bias, to produce in people who looked like her. The court reporter's fingers hovered above the keys, waiting for a sentence that would never come the way anyone in that room expected. If you're watching this and you've ever walked into a room where the rules applied differently to you before you even opened your mouth, subscribe now, because what unfolds in this courtroom will keep you watching until the very last second. 72 hours earlier, a 10-year-old Nissan Altima with a hairline crack in the windshield and Mississippi plates pulled into the parking lot of an extended stay motel off Interstate 55, 3 miles south of downtown Jackson. The engine ticked in the October heat as the driver cut the ignition and sat for a moment, studying the building through the passenger window. Amara Langston was 37 years old, with close-cropped natural hair and hands that moved with the deliberate economy of someone who had learned, in places she would not discuss, that unnecessary motion attracted unnecessary attention. She wore a plain gray cotton shirt, dark jeans, and flat-soled shoes that made no sound on pavement. No jewelry, no watch, no briefcase, nothing that announced education or income or authority. She checked into room 214 using a prepaid debit card and a Mississippi driver's license that listed an address in Vicksburg, a town she had visited exactly once, 18 months ago, to establish the residency trail that would support this identity if anyone bothered to check. The motel clerk barely looked at her, another unremarkable guest in a building full of them. Inside the room, she closed the door, set the deadbolt, and began a sequence that would repeat every morning for the next 3 weeks. She made the bed first, hospital corners, sheets pulled taut enough that a quarter would bounce, then arranged her toiletries along the bathroom counter in a single row, ordered by height. Toothbrush on the left, travel-size shampoo in the center, a small first aid kit on the right. Her shoes went parallel at the foot of the bed, toes pointing toward the door. Her bag, a worn canvas backpack with no visible logos, hung on the hook behind the bathroom door. Always the same hook, always zipped the same way. From the backpack's interior pocket, the left one, always the left one, she removed a black and white composition book with a marbled cover. She placed it on the nightstand, spine facing the wall. Then she sat on the edge of the bed and counted the exits. 1 door, 1 window. The window opened onto the parking lot, ground floor, no screen. The fire escape was 11 steps to the left down the exterior corridor. She had noted it while walking from the car. 3 ways out, acceptable. She opened the composition book to the first blank page and wrote the date in small, precise handwriting. October 4th. Below it, a single line. Arrived Jackson, 1547 hours. Room 214. Sightlines acceptable. Then she closed the book, placed it back in the left pocket, and went to sleep at 8:45 p.m. with the lights off and her shoes still parallel at the foot of the bed. The Hinds County Courthouse sat on a block of South President Street, like a monument to the idea that justice was a building you walked into rather than a principle you carried with you. Limestone columns, wide steps, a metal detector at the front entrance staffed by 2 bailiffs who processed the morning crowd with the cheerful efficiency of people who had stopped seeing individual faces decades ago. Amara arrived at 8:30 a.m. on October 5th, her first full day in Jackson, wearing the same plain clothes from the day before, canvas backpack over one shoulder, composition book in the left pocket. She joined the line of attorneys, defendants, families, and witnesses filing through the metal detector and waited. The line moved. She moved with it. When she reached the front, a bailiff the size of a refrigerator looked at her backpack and then at her face and then at her backpack again. "What's the purpose of your visit today, ma'am?" His name tag read Calloway. His posture read ex-military, shoulders squared, chin level, weight balanced on both feet. The kind of man who had been trained to occupy space and had never unlearned the habit. "I'm here to observe public proceedings." She kept her voice neutral, unaccented, pitched at the mid-range that drew the least attention. "I'm doing research on courtroom procedures." Calloway's eyes tracked from her face to the composition book, visible in the backpack's open pocket. He held out his hand. She gave him the book. He flipped through it, blank pages except for the single entry from last night, and handed it back without comment. "Public gallery is upstairs, courtroom 3. He paused. "Seating for the public is in the back. Front rows are reserved for attorneys and family." She was already planning to sit in the back. The instruction was not about logistics. It was about placement, a reminder delivered with the mechanical precision of a man who had said it many times to certain kinds of visitors that there was a geography of belonging in this building, and she was being assigned her coordinates. "Thank you," she said, and walked through. Courtroom 3 was Judge Clement Braxton's domain. She knew this already, had known it for 4 months, since the first batch of 42 U.S.C. Section 1983 complaints had landed on her desk in Washington, each one describing a different defendant, a different charge, a different day, but all sharing the same 3 elements: a black defendant, a disproportionate outcome, and the name Braxton. She sat in the last row of the gallery, opened her composition book, and watched. The morning docket moved with the brisk efficiency of a system that had optimized itself for speed at the expense of everything else. A white man in a polo shirt charged with DUI, 3rd offense, received a continuance without being asked to justify the request. His attorney mentioned a scheduling conflict. Braxton nodded. "Granted, see the clerk for a new date." Total interaction, 45 seconds. A black woman charged with shoplifting, 1st offense, value under $50, stood at the defense table with a public defender who had clearly not reviewed the file. She asked for a continuance to gather character references. Braxton's jaw tightened. "Ms. Davis, this court has limited resources. Your case has been on the docket for 3 weeks. If you're not prepared to proceed today, I'm inclined to enter a default judgment. Would you prefer that?" The woman's eyes widened. Her public defender leaned in and whispered something. She shook her head, pleaded no contest. Braxton sentenced her to 60 days probation and a fine of $250 for a first offense petty theft that in most Mississippi courtrooms would have been dismissed or deferred. Total interaction, 3 minutes and 12 seconds. Amara timed it on her phone, held below the bench line, screen dimmed. She wrote in the composition book, "Continuance denied, Davis, 1st offense. PD unprepared, fine disproportionate. Compare with DUI 3, white male, continuance granted, no objection, 45 seconds. The notations were small, precise, compressed into a personal shorthand that used abbreviations and margin symbols no one else could read, because they were never meant to be read by anyone else. Not yet. At the clerk's window during the morning recess, Amara waited. The counter was staffed by 2 women, a senior clerk with reading glasses on a beaded chain, and a young man behind her who moved with the mechanical efficiency of someone completing tasks he had memorized but never questioned. The senior clerk's nameplate read Gina Prescott. She was on the phone when Amara approached, a personal call, audible enough that Amara could hear her discussing a church potluck, and continued the call for another 4 minutes while Amara stood at the window. 3 white attorneys approached during those 4 minutes. Each time, Prescott covered the phone's mouthpiece, smiled, and helped them, pulling files, stamping forms, handing over docket printouts, before returning to her call. Each interaction took less than 90 seconds. When the call ended, Prescott finally looked at Amara. "Can I help you?" "I'd like a copy of today's public docket for courtroom 3. Prescott's fingers moved to the keyboard. She typed slowly, paused, typed again, frowned at the screen. "System's running slow today." The smile was professionally regretful. "You're welcome to come back tomorrow." "I can wait." The smile cooled by several degrees. Prescott printed the docket, a single page, and slid it across the counter without making eye contact. The entire transaction, from Amara's arrival at the window to receipt of the document, had taken 43 minutes. Behind Prescott, the young man at the filing cabinet, Amara would later learn his name was Jonah Wyatt, 24 years old, 2 years on the job. Glanced up once during the exchange. His expression was blank, practiced. The blankness of someone who has seen something repeated so many times that reaction has been replaced by recording. He looked back down at his filing, said nothing, continued his work. On a bench outside the courthouse, Amara ate a sandwich she had packed at the motel that morning. She sat alone. Attorneys passed in pairs and trios, laughing, carrying coffee from the shop across the street. None of them glanced at her. A white woman in the gallery earlier that morning had moved her purse, a designer bag with a visible logo, to the far side of her lap when Amara sat 3 seats away. The gesture was small, practiced, and delivered with the unconscious fluency of someone who had been performing it for so long that it no longer registered as a choice. Amara opened her composition book and drew a small map of the courthouse's ground floor from memory. She marked the entrances, the clerk's window, the courtroom doors, and, with a small X, the locations of the security cameras she had counted during her walk through the building. 9 cameras, 3 blind spots. She noted them all. Then she closed the book, finished her sandwich, and returned to the gallery for the afternoon session. 2 days passed. Amara repeated her routine with the discipline of a woman who understood that the most effective form of observation was to become so predictable that the observed stopped noticing the observer. Same seat, same time, same backpack, same composition book. The bailiffs began waving her through the metal detector without comment. Prescott ignored her at the clerk's window. Calloway stopped checking her bag. She was becoming furniture, and furniture heard everything. On the morning of October 7th, day 4, Amara did not go to the courthouse. She drove instead to a stretch of road on the eastern edge of the county, where Linden Road cut through flat agricultural land before intersecting with a state highway. The property on either side was rural. Overgrown lots, a few scattered houses, a decommissioned grain elevator visible in the distance. Along the shoulder, a chain-link fence marked the boundary of a 3-acre parcel that appeared, from the road, to be unused. This parcel had appeared in 4 separate Section 1,983 complaints over the past 2 years. In each case, a black resident had been cited for trespassing on this property, despite the fact that the citations were issued while the individuals were standing on the county road shoulder, public land outside the fence line. In each case, the citing officer was Deputy Kirk Oakley. In each case, the charges were upheld by Judge Braxton. In each case, the property owner who filed the complaint was listed as K. Oakley. The arresting officer and the property owner were the same person. No one had connected the two until the complaints were cross-referenced in Washington. Amara parked on the road shoulder, 20 feet from the fence. She stepped out, walked to the fence line, and examined the chain link for posted signage. Mississippi Code, Section 97-17-87, the state's trespassing statute, required either posted notice on the property or a direct verbal warning to the individual, followed by refusal to leave before a trespassing charge could be sustained. Posted notice meant signs, visible signs, signs that a reasonable person could read from the point of entry. There were no signs. She photographed the fence from 4 angles, capturing the absence of signage along the entire visible length. She photographed the county road marker, a green metal post with white reflective numbers, that confirmed she was standing on public right-of-way. She photographed the property line, which began at the fence post, 6 feet from where she stood. She was on the road, on public land, documenting a fence. The white SUV appeared in her peripheral vision before she heard it. No lights, no siren, just a county-issued vehicle pulling onto the shoulder behind her Nissan with the unhurried confidence of a man arriving at a destination he had chosen, not one he had been dispatched to. Deputy Kirk Oakley stepped out. He was 41 years old, 6'2", with the build of a man who had been athletic in his 20s and had since traded muscle for mass without noticing the difference. He wore the tan uniform of the Hinds County Sheriff's Department. His badge caught the midday sun. His right hand rested on his belt, not on his weapon, but close enough to the holster that the geometry communicated intent without requiring action. "Ma'am?" He walked toward her with long, measured strides. "What are you doing out here?" "Photographing the fence line." She held up her phone, screen facing him. "For a research project." "This is private property." He gestured toward the fence with his left hand, a broad, encompassing wave that included the road, the shoulder, and the air she was breathing. "The owner called in a trespassing complaint. I'm standing on the county road shoulder." She pointed to the green marker post. "The property line begins at the fence post. This is a county right-of-way." Oakley's expression did not change. He had the face of a man who had practiced not reacting to information that contradicted his intentions. He reached for the radio on his shoulder, keyed it, and spoke without looking away from her. "Dispatch, Unit 42. I'm at Linden Road, East Parcel. Confirming trespassing complaint. Suspect is on scene." She heard the dispatcher's voice, tinny, distorted by the radio's small speaker. "Confirm the complaint number." She noted that Oakley did not provide the complainant's name, because the complainant was Oakley. "Ma'am, I'm going to need you to step away from the fence and provide identification." "Can I see the complaint number, please, and the name of the complainant?" The request was reasonable. It was also, in Oakley's experience, unusual. Most people he stopped on this road, and they were always the same kind of people, either complied immediately or argued emotionally. Calm, procedural questions disrupted the script. His jaw tightened. A small thing, a twitch of the masseter muscle that lasted less than a second. But Amara saw it. She had been trained to see it. "Ma'am, I'm telling you, you're trespassing. The property owner called it in." His voice dropped half a register. "Now I need your ID, or I'm going to have to place you under arrest. I'd like to note for any recording devices present that I am standing on the county road shoulder, outside the fence line, on public land. There is no posted no trespassing signage on this property. I have not been given a verbal warning to leave. I am cooperating with your request for identification." She reached slowly into her backpack, left pocket, always the left pocket, and removed the Mississippi driver's license. She held it out with 2 fingers, arm extended, the way someone holds an object when they want the gesture to be visible from a distance, from a camera's distance. Oakley took the license, studied it. His eyes moved from the photo to her face and back. He reached for the camera on his chest, a body-worn recording device required by department policy, and adjusted it with his left hand. The gesture was quick, practiced. Amara could not see the screen, but she noted the timing. He touched the camera 4 minutes into the encounter. Department policy required activation at first contact. 4 minutes of potential gap in the footage. She filed the number. "Amara Langston, Vicksburg address." He read from the license. "Long way from home, Ms. Langston. Is there a question in that, Deputy?" He looked at her for a long time. The silence was intentional, the kind of pause law enforcement officers deploy when words are not producing the desired effect, and they want the absence of words to do the work instead. She recognized the technique. She had studied it. "Turn around, please. Hands behind your back." "Am I being arrested?" "Trespassing. Mississippi Code 97-17-87. You were warned and you refused to leave." "I was not warned. I was asked for identification, which I provided. And this is a county—" "Ma'am," his voice hardened. "Turn. Around." She turned around, placed her hands behind her back, felt the metal close around her wrists, Cold, tight, the left cuff torqued harder than the right, a technique she recognized as deliberate. Not enough to leave marks, just enough to communicate who held the power. He walked her to the SUV. She counted steps. 14 from the fence to the vehicle. She noted the position of the sun, still high, casting short shadows. She noted that her phone was in the backpack, which Oakley had left on the road shoulder beside her car. She noted that the backpack was unzipped. In the back seat of the SUV, through the partition, she could see the dashboard-mounted camera. Its red light was on, recording. She sat still, counted breaths, waited. The Hinds County Sheriff's Department processed her at a precinct that smelled like industrial cleaner and burned coffee. Fluorescent lights hummed at a frequency that made the white walls look faintly green. She was photographed, fingerprinted, and led to a processing desk where a booking officer, a woman in her 50s with tired eyes and a name tag that read Hendricks, began entering her information into a computer system that appeared to be running software from the previous decade. "Is there a standardized intake procedure?" Amara asked, her voice conversational, unforced. "Or does each shift follow its own protocol?" Hendricks looked up. The question was unusual, not in its content, which was mundane, but in its precision. The word protocol hung in the air between them for a moment, carrying more weight than a trespassing defendant's vocabulary typically supported. "Standard procedure," Hendricks said, and continued typing. Amara held her wrists out for the fingerprint scan before Hendricks asked for them, muscle memory overriding her cover identity for half a second, before she caught herself and let her hands fall back to her sides, waiting to be directed. Hendricks did not notice, or, if she noticed, she did not remark on it. The charge was filed: trespassing, misdemeanor, Mississippi Code, Section 97-17-87. Bail was set at $2,500. For a misdemeanor trespassing charge in Hinds County, the standard bail schedule recommended $500. The amount Amara was assessed was 5 times the standard. No explanation was provided. No enhancement factors were cited. The number simply appeared on the booking form, printed by a system that accepted whatever a judge authorized. Amara paid with the prepaid debit card. She signed the release form. She collected her personal effects: backpack, phone, composition book, driver's license, and noted, without comment, that the backpack's zipper was now on the right side. She always zipped it from the left. She walked out of the precinct at 7:12 p.m. into an October evening that smelled like diesel and warm asphalt. Her Nissan was in the impound lot across the street, released with her, no hold. She drove back to the motel, parked, and sat in the car for 3 minutes before going inside. In room 214, she removed the composition book from the left pocket and opened it to a fresh page. She wrote for 40 minutes. Small, precise handwriting. Margin notations. Abbreviations that compressed complex observations into symbols no one else could decode. When she finished, she placed the book under her pillow, always under the pillow, always centered, and went to sleep. The next 5 days moved with the grinding momentum of a system that had been designed to exhaust rather than adjudicate. Amara returned to the courthouse each morning. Same time, same backpack, same seat in the back row of the gallery. But now she was no longer anonymous furniture. Now she was a defendant. The difference was architectural. Before her arrest, she had been invisible. One of hundreds of people who passed through the building's metal detectors each week, observed by no one, remembered by fewer. Now she was visible, a name on a docket, a case number, a file in Gina Prescott's system. And visibility in Braxton's courthouse came with a specific set of consequences. Prescott's demeanor shifted from passive obstruction to active hostility. When Amara appeared at the clerk's window on October 8th to file a motion for discovery, requesting the body cam footage from her arrest, the 911 call recording, and the original complaint form, Prescott accepted the papers with a smile that showed too many teeth and not enough warmth. "I'll get these processed. Should be in the system by end of day." 2 days later, when Amara returned to confirm the filing, Prescott's screen showed no record of it. "I'm sorry, I don't have anything under that case number for discovery." Prescott's tone carried the particular sweetness of someone who was enjoying the confusion they had manufactured. "Are you sure you filed it here?" Amara reached into her backpack and produced her phone. On the screen, a time-stamped photograph of the filing receipt, taken at the clerk's window on October 8th at 9:17 a.m., showed the motion, the case number, and Prescott's own stamp in the corner. I have a photo of the receipt, time-stamped. Prescott's expression flickered. A micro-movement, the briefest contraction of the muscles around her eyes, that passed so quickly it could be denied. She took the phone, looked at the photo, and handed it back. Must have been a system error. I'll refile it now. The motion entered the system on October 10th, 2 days after it should have been processed. 2 days of delay that compressed Amara's pre-trial preparation timeline and would, if left unaddressed, provide Braxton with grounds to deny a continuance on the basis that the defense had failed to file in a timely manner. Amara photographed the new filing receipt. Time-stamped, stored. She was beginning to understand the machinery, not its function. She had understood that from Washington, from the complaints, from the data. She was understanding its texture, the way it felt to stand at a window and be made to wait, the way it felt to file a document and watch it disappear, the way it felt to be processed. That word, processed, through a system that treated her presence as an error to be corrected rather than a right to be protected. She had read about it, analyzed it, built cases around it. But reading about institutional bias and standing inside it were different experiences. The way reading about cold is different from shivering. The gossip started on day 6. Amara did not hear it directly. She heard it the way you hear a frequency shift, not as words, but as a change in the room's acoustics. The way attorneys in the hallway stopped talking when she passed. The way courthouse staff glanced at her, and then at each other, with the complicit recognition of people who share a narrative they have constructed together. Prescott had been efficient. By the afternoon of October 9th, the story had propagated through the building's informal network with the speed and reliability of a system designed for exactly this purpose. That trespassing defendant had been lurking around the courthouse for days before her arrest, watching, taking notes. What kind of person does that? And did you see the way she talked to Gina at the window? Like she thought she was somebody. The implication was precise. Not stated explicitly, never stated, because explicit statements could be quoted, but embedded in tone and inflection and the raised eyebrow that followed the word lurking. She wasn't a researcher, she wasn't a curious member of the public, exercising her right to observe her own justice system. She was casing the building, she was suspicious, she was a threat dressed in plain clothes, and the courthouse needed to be protected from her. On the morning of October 10th, Amara stood at the water fountain on the 2nd floor when she heard 2 women's voices drifting from the clerk's break room. The door was ajar. She recognized Prescott's cadence, the particular lilt she used when delivering gossip dressed as concern. I'm just saying, if she's been watching this building since before her arrest, that's not normal. You don't sit in a courtroom for 3 days straight unless you're planning something. I told building security. They said they'd keep an eye on her. The second voice, unfamiliar, responded with the verbal equivalent of a nod. You think she's one of those sovereign citizen types? I think she's trouble, and I think the judge should know she's been observed taking photographs of the building's entrance. She had photographed nothing inside the building, not a single image. The composition book contained handwritten notes and hand-drawn maps, no photographs. But truth was not the currency of courthouse gossip. Plausibility was. The narrative served a function. It pre-justified whatever happened to Amara next. If Calloway escalated his security checks, it was because the staff had reported concerns. If Braxton treated her with particular hostility, it was because he had been briefed on a potential threat. If her motions disappeared or her filings were delayed, it was the system protecting itself from someone who had already been categorized as dangerous. Amara stepped away from the fountain, wrote a single line in the composition book. Prescott narrative active, building security notified, timeline accelerating. Calloway upgraded his interactions accordingly. Beginning on October 9th, every time Amara entered the building, she was subjected to what he called a random security check. Bag search, handheld metal detector wand, pockets emptied onto the counter. The process took between 4 and 7 minutes, depending on how slowly Calloway decided to move. During these checks, white visitors passed through the metal detector behind her without pause. Some smiled at Calloway. He smiled back. He did not smile at Amara. On the morning of October 10th, during one of these checks, Calloway's hand closed around her upper arm. "Step over here, please." He steered her to the side of the security station. not roughly enough to be called a shove, not gently enough to be called guidance. His grip was firm, fingers pressing into the muscle above her elbow, creating a pressure point that would ache for 20 minutes after he released her. Need to check your bag more thoroughly. She did not flinch, did not pull away, did not react with the alarm or indignation that his grip was calibrated to produce. She absorbed the contact with a stillness that came from somewhere deeper than composure, a trained absence of reaction that suggested familiarity with situations where flinching could be reinterpreted as resistance, and resistance could be reinterpreted as grounds for escalation. Calloway held her arm for 6 seconds, then released her. He searched the bag, removing the composition book, flipping through its pages with the deliberate slowness of a man who wanted her to know he could, and handed it back without comment. She entered the courthouse, sat in her seat, opened the composition book and noted the time, the duration of the contact, and the pressure location. Then she turned to the docket page and continued her observations as though nothing had happened. Because in her composition book, everything that happened was happening for a reason she could not yet share. The arraignment came on October 9th, a Thursday morning, 8 days before the scheduled pre-trial hearing that would determine whether her case went to trial or was dismissed. Amara stood at the defense table in courtroom 3, wearing the same clothes she had worn every day, plain, unremarkable, invisible, beside a public defender named Dale Booker, who had 47 active cases and had met her for the first time 8 minutes ago in the hallway outside the courtroom. Their meeting had lasted the length of the hallway. "Ms. Langston, I'm Dale Booker, your assigned counsel." He was 53, balding, with the permanently exhausted expression of a man whose caseload exceeded his capacity by a factor of 3. His briefcase was a catalog of chaos, papers jutting at angles, folders dog-eared, a half-eaten granola bar wedged between 2 file folders. He had reviewed her case file during the elevator ride from the first floor. 12 seconds of preparation for a proceeding that could determine the next 6 months of her life. Trespassing charge, single count. Have you been in trouble before? No. Good, good. Listen, Judge Braxton doesn't like defendants who waste his time. My advice? Plead no contest. You'll get a fine, couple hundred maybe, and time served. In and out, done by lunch. I'm pleading not guilty. Booker stopped walking, turned to face her. His expression carried the particular fatigue of a man who had given the same advice to hundreds of clients and had long ago stopped being surprised when they didn't take it, but had never stopped being tired by the consequences. "Ms. Langston, this is a misdemeanor. The maximum sentence is 6 months and a $1,000 fine. But if you fight it and lose, and Braxton doesn't lose in his own courtroom, he'll give you the maximum. I've seen it, repeatedly. I'll represent myself, if necessary." Booker studied her. Something in her tone, not the words, which were ordinary, but the precision behind them, made him pause. Most defendants who said, "I'll represent myself," were either angry or naive. This woman was neither. She was making a calculation, and the variables she was weighing were invisible to him. "Your choice," he said finally. "I'll stay on record as counsel for now, but I'd encourage you to reconsider." In the courtroom, Braxton presided with the imperious efficiency of a man who believed his bench was a throne, and his courtroom was a kingdom. He moved through the morning docket with speed, granting continuances to defendants he favored, denying them to defendants he didn't, the sorting mechanism invisible to anyone who wasn't counting, until Amara's case number was called. Case number 24783, State of Mississippi versus Langston, trespassing, single count. The court clerk, Prescott, seated at the desk below the bench, read the number without looking up. "Defendant is present with counsel." Braxton looked down at Amara. The fluorescent light caught his reading glasses again, turning his eyes into blank discs of reflected light. "Ms. Langston, you've had 5 days since your arrest to secure counsel and prepare your defense. This court doesn't operate on your schedule. How do you plead?" "Not guilty, Your Honor." The words landed in the courtroom like stones dropped into still water. Braxton's jaw set. Beside Amara, Booker shifted his weight from one foot to the other, the unconscious fidget of a man bracing for impact. "Very well. The court notes the plea. Trial is set for October 24th. Braxton shuffled papers. "Defendant's motion for discovery? Filed on October 8th, Your Honor," Amara said. "I have no record of that motion." Braxton looked at Prescott. Prescott shook her head. Refiled on October 10th due to a processing error in the clerk's office. I have time-stamped documentation of both filings. Braxton's pen stopped moving. The silence in the courtroom lasted 4 seconds, long enough for the court reporter to look up from her keys, long enough for Booker to glance sideways at his client with an expression that mixed surprise with something closer to alarm. "Counselor," Braxton said to Booker, not to Amara, "advise your client that this court operates on its own timeline. The motion will be reviewed when it's reviewed. Your Honor, the motion was filed. I said it will be reviewed." The gavel came down once. Next item. The next item was ADA Fielding Marsh, who rose from the prosecution table with the smooth confidence of a man whose ambitions were precisely calibrated to the approval of the judge he served. Marsh was 36, Harvard Law, recruited to the Hinds County DA's office 2 years ago by a judge who had seen in him a useful combination of intelligence and loyalty. He had never lost a case in Braxton's courtroom. The statistic was not a reflection of his legal skill. It was a reflection of the courtroom he practiced in. Your Honor, the state moves to amend the charges against the defendant. Marsh opened a folder with the practiced gesture of a man presenting a gift he had prepared in advance. In addition to the trespassing charge, we're adding a count of interference with law enforcement operations under Mississippi Code, Section 97-9-73. Booker stood up. Your Honor, that statute covers resisting arrest. My client cooperated fully with... The defendant refused a lawful order to vacate the premises and engaged in a pattern of noncompliance consistent with interference, Marsh interrupted. Deputy Oakley's report indicates the defendant questioned his authority, refused to provide identification in a timely manner, and... I provided identification immediately upon request. Amara's voice was level, quiet. The kind of quiet that carried further than a shout because it forced everyone in the room to lean in to hear it. And I have not been shown the deputy's report. The system was stacking the deck, but they picked the wrong defendant to railroad. If you want to see what happens when someone who looks powerless turns out to be anything but, keep watching. Braxton's gavel hit the bench. Ms. Langston, you will address this court through your counsel. My counsel hasn't received the amended charges, Your Honor. He can't respond to what he hasn't seen. The courtroom went silent. Marsh's folder remained open on the prosecution table, its contents suddenly less impressive. Booker looked at Amara with the expression of a man watching someone walk a tightrope over a canyon without a safety net. Terrified, awed, and privately certain this was going to end badly. Braxton leaned forward. The amended charges are noted. Defendant will receive copies through the clerk's office. Defense has 5 days to respond. Are we done here? Your Honor, Amara said, I'd like to request a continuance to prepare for the additional charge. Denied. The word was a door slamming. You have 5 days. Use them. Court is adjourned until 2 p.m. The gavel fell. Braxton rose. The courtroom rose with him, everyone standing in unison, a choreography of deference that the judge expected and the system enforced. Amara remained standing because she had already been standing. But she watched him exit through the side door with an expression that Booker, had he been looking, might have recognized. It was not anger. It was not fear. It was inventory. She was counting the violations. Marsh's additional charge, interference under Section 97-9-73, was a stretch that required redefining the word interference to include asking questions during a lawful encounter. The statute required physical resistance or obstruction. Amara had done neither. She had asked for a complaint number. She had identified herself. She had turned around and placed her hands behind her back when instructed. But in Braxton's courtroom, the statute meant what Braxton said it meant, and Marsh was skilled enough to frame the charge in language that would survive the court's own self-review, even if it would collapse under appellate scrutiny. Amara did not plan to let it reach an appeal. She had a different timeline. In the courthouse hallway, Booker caught up with her. That was... Ms. Langston, I need to be honest with you. What you did in there, challenging Braxton directly, it's not going to help your case. What would help my case? A plea deal, no contest. Marsh will reduce to a single count. You'll get probation. For a trespassing charge with no posted signage and no verbal warning. Booker opened his mouth, closed it, opened it again. How do you know about the signage requirement? She paused. A fraction of a second, the kind of hesitation that, to a careful observer, might have suggested she had said more than her cover identity warranted. Then she recovered. I read the statute. It's posted on the courthouse's public information board, second floor near the restrooms. Booker frowned. He had worked in this courthouse for 11 years. He had never read the public information board. Listen, I'll stay on record. But if you're going to represent yourself in practice, at least let me file the motions. Braxton won't accept pro se filings from a defendant who has appointed counsel. It's fine. I'll draft them. You file them. You'll draft them? Is that a problem? It was not a problem. It was an anomaly. Defendants drafted motions in prison law libraries and in legal aid clinics, and in the kind of desperate late-night research that produced documents heavy on passion and light on procedure. They did not draft motions using the word draft the way an attorney would use it, as a verb describing a professional activity, rather than an act of desperation. Booker said nothing, nodded, walked away. In the parking lot, Amara sat in her Nissan and allowed herself 30 seconds of stillness. Not rest, not reflection. Stillness, the active absence of motion that she used to reset between operational phases. Then she opened the composition book and wrote, Marsh added section 97-9-73. Stretch charge. No physical resistance, no obstruction. Politically motivated. Braxton denied continuance. Discovery motion buried by clerk. Refiled. Booker compromised by caseload, not malice. System functioning as designed. She closed the book, started the car, drove back to the motel. The pre-trial hearing was scheduled for October 17th. In the 8 days between the arraignment and the hearing, Amara built her case the way she had been trained to build cases, not from the top down, with theories and arguments, but from the bottom up, with documents and data. She spent her mornings at the Hinds County Public Library, 3 blocks from the courthouse, using the public access terminals to search legal databases. The library's Westlaw subscription was limited, a basic package that provided access to case law and statutes but not the proprietary research tools she was accustomed to. And the librarian, a middle-aged man named Gerald, who wore bow ties and spoke in the hushed tones of someone who considered silence a civic virtue, had offered to help her navigate the system. She navigated it without help. Her fingers moved through the search interface with the muscle memory of someone who had used it, or something very like it, thousands of times. Gerald noticed, said nothing. But he stopped offering help after that first morning, and instead placed a fresh glass of water on her desk each day at 10 a.m., a gesture of quiet respect that was notable precisely because it was the only kindness she received during those 8 days. She filed a FOIA request with the Hinds County Sheriff's Department on October 12th, requesting the body cam footage from her arrest on October 7th. The request was specific. Unit BC-0447. Assigned to Deputy Kirk Oakley, time window 1400 hours to 1530 hours. She cited the Mississippi Public Records Act, Section 25-61-1 at SEQ, and included a prepaid check for the standard processing fee. She also filed a second FOIA request for the courthouse's CCTV footage from the main entrance security checkpoint, specifically the footage from October 9th and 10th during Callaway's random security checks. Both requests were acknowledged by form letter. The responses would come later. She expected them to be incomplete. On October 14th, 3 days before the pretrial hearing, Amara spent the evening at the county library reviewing case law on Mississippi's trespassing statute. The library closed at 9 p.m. She left at 8:55, walked to her Nissan in the parking lot, and drove north on County Road 18 toward the motel. The road was 2 lanes, no streetlights, bordered by drainage ditches and wire fencing. At mile marker 4, the road curved west through a stand of pin oaks whose branches formed a canopy that blocked the moonlight and turned the asphalt into a dark tunnel. She saw the headlights in her rearview mirror first. Then the headlights disappeared, turned off, and the only thing behind her was the sound of an engine accelerating in the darkness. The impact came at the rear bumper, passenger side, a sharp metallic crack that sent her Nissan sliding sideways across the center line and onto the gravel shoulder. The car's trajectory carried it into the drainage ditch at an angle, front wheels in the gravel, rear wheels in the ditch, the frame tilted at 15 degrees, both airbags deployed. The steering column airbag caught her face, a sharp, chemical-smelling impact that split the skin above her left eye and drove her head backward into the headrest. The sedan that hit her, dark, low, no headlights, did not stop. She heard the engine recede into the darkness, accelerating, tires on asphalt, and then nothing. Silence, night insects. The tick of her cooling engine. She sat in the car for 90 seconds, not frozen, not panicking, counting, assessing, left hand, functional, right hand, functional. Ribs, sharp pain on the left side, worse with deep breaths, consistent with contusion or hairline fracture. Left eye, bleeding, vision partially obscured by blood. Legs, functional, spine, no radiating pain, no numbness, no tingling. She was alive. She was conscious. She was operational. She did 3 things before calling 911. First, she photographed the tire marks on the road, her own car's skid marks, and, on the opposite lane, a second set of marks where the sedan had swerved back onto the asphalt after the impact. Her phone's camera captured the marks with timestamps. 21:04 hours, October 14th. Second, she photographed her car from 4 angles: front, rear, driver's side, passenger side, documenting the point of impact on the rear bumper and the damage to the ditch side undercarriage. The rear bumper showed a transfer mark, dark blue metallic paint, pressed into the silver finish of her Nissan by the force of the collision. Third, she walked 40 yards back along the road and photographed the paint transfer in close-up. Dark blue, metallic flake, factory finish, the kind of paint used on fleet vehicles. Then she called 911. Dispatch ID J7734, 21:08 hours, October 14th. Single vehicle accident reported on County Road 18, mile marker 4. Caller states she was struck by an unidentified vehicle that fled the scene. Ambulance dispatched. Deputy responding. K. Oakley. Oakley, of course. The county's eastern zone was his patrol area, the same zone that contained the property where she had been arrested, the same zone that contained the road where she had just been run off it, the same deputy responding to the same defendant on the same stretch of road where his jurisdiction was absolute and his accountability was non-existent. He arrived 12 minutes after the dispatch call, lights on this time, pulling his SUV behind her Nissan with the same unhurried confidence she recognized from their first encounter. He stepped out, walked to her car, and looked at the damage with the expression of a man reviewing a situation he had already decided how to categorize. "Ma'am, you all right?" "I was struck from behind by a vehicle traveling without headlights. The vehicle fled the scene." "Uh-huh." He circled the car, looked at the ditch, looked at the road. He did not look at the tire marks on the opposite lane. He did not look at the paint transfer on the rear bumper. He wrote in his notepad with the slow, deliberate penmanship of a man composing a narrative rather than recording facts. "Looks like you lost control on the curve. These roads get slick after sundown. Dew on the asphalt." There was a second vehicle, dark-colored, no headlights. It made contact with my rear bumper at, "Ma'am, I appreciate the detail, but I've been driving this road for 15 years. This curve is a known hazard. We get 3-4 single-vehicle incidents here a year." He wrote, "Single vehicle accident. Driver lost control on curve. No other vehicles observed. The ambulance arrived. 2 EMTs examined her in the back of the rig, cleaned the cut above her eye, applied butterfly strips, palpated her ribs, and noted tenderness consistent with bruising. They recommended a hospital visit for x-rays. She declined, signed the refusal form. Oakley handed her a copy of the incident report. She read it in the ambulance's interior light. Single vehicle accident. No mention of a second vehicle, no mention of paint transfer, no mention of tire marks in the opposite lane, no mention of her photographs. She signed the acknowledgement line, said nothing, drove the battered Nissan back to the motel at 30 miles per hour, both hands on the wheel, ribs aching with every breath. In room 214, she sat on the edge of the bed and held a cold washcloth against the cut above her eye. The blood had dried in a thin line from her eyebrow to her cheekbone. It would scar. She could feel it. the particular sting of a wound that cuts deep enough to leave a permanent mark but shallow enough to heal without stitches. She opened the composition book, wrote for 20 minutes. Then she did something she had not done since arriving in Jackson. She switched SIM cards. From the backpack's interior pocket, not the left one this time, but a smaller compartment behind it, secured with a hidden zipper, she removed a second SIM card. She swapped it into her phone, waited for the network to register, and sent a single text message to a number with a Washington, D.C. area code. 4 words, pattern confirmed, escalating, continue. The response came 11 minutes later. 3 words, acknowledged, stay safe. She switched back to the original SIM card, placed the second one in the hidden compartment, closed the backpack, placed the composition book under her pillow. She did not sleep that night. She lay on her back, ribs throbbing, and listened to the sound of trucks on Interstate 55, and thought about the color of the paint on her bumper. Dark blue, metallic, fleet vehicle finish. The same color as every county-issued law enforcement vehicle she had seen in Hinds County since her arrival. The next morning, October 15th, she returned to the courthouse, bruised ribs taped under her shirt, butterfly strips on the cut above her eye. Moving slowly enough that the pain was manageable, but fast enough that she didn't draw stares from anyone watching the entrance. Calloway was watching. He was standing outside the security checkpoint when she arrived, not behind the desk where he usually stationed himself, but in the corridor between the metal detector and the elevator bank. Arms crossed, weight forward on his toes, the posture of a man who had been waiting. "Morning, Ms. Langston." He said her name the way someone says the name of an animal they've decided to corner. "What happened to your face?" "Car accident." "Looks like more than a fender bender." He took a step toward her, close enough that she could smell the coffee on his breath and see the capillaries in his eyes. "You sure you're okay to be here? We wouldn't want you passing out in the courtroom. Liability issue." "I'm fine. See, here's the thing." He reached out and tapped the butterfly strips above her eye. Not gently, not roughly, but with the casual precision of a man touching something he wanted her to know he could touch whenever he wanted. She felt the adhesive pull against the wound. Fresh pain, sharp, brief. "You've got an open wound. Building policy. Open wounds are a biohazard risk. I can't let you through until medical clears you." "There's no such policy." "There is now." He smiled. The smile of a man who understood that policy was whatever the person with the badge said it was, and the appeal process, if one existed, would take longer than the morning session. Amara felt the heat rise in her chest. Not anger, or not only anger, something older, something that lived in the space between composure and the physical reality of a man twice her size blocking her access to a public building because he could, because no one would stop him. Because the system he represented was designed not to stop him. She breathed, counted to 3, felt her ribs protest. "I'd like to see the written policy, please. Title, section number, and the date it was adopted." Calloway's smile dimmed. He held her gaze for 5 seconds, a long time when someone is standing close enough to feel your breath, and then stepped aside. "Get that looked at," he said as she passed. His hand brushed her shoulder, the same shoulder he had gripped on October 10th, and she felt his fingers close for half a second before releasing. A reminder. A claim. She walked to the elevator, pressed the button, did not turn around. In the composition book, she wrote, "Calloway, physical contact, second incident. Wound aggravation, fabricated biohazard policy. Blocked access, 3 minutes 40 seconds. Witnesses, 2 bailiffs at desk, 4 civilians in line. The details would matter later. Every detail would matter later. But for now, they were ink on paper in a book that no one but her could read. The FOIA responses arrived on October 16th, one day before the pretrial hearing, with the bureaucratic punctuality of a system that had learned to time its denials for maximum inconvenience. The first response from the Hinds County Sheriff's Department regarding the body cam footage from her arrest. "Regarding your request for footage from Unit BC-0447, the department regrets to inform you that the requested footage is unavailable due to an equipment malfunction during the time period specified. The device's recording function experienced a technical error that has since been resolved. No footage exists for the requested window." Equipment malfunction. The excuse was standard. She had seen it in dozens of cases, in dozens of departments, across a dozen states. It was the institutional equivalent of a shrug. We don't have what you're looking for, and we're not going to help you find it. The second response, regarding the courthouse CCTV footage, per Hinds County policy, security footage is retained for a period of 7 calendar days before being overwritten in the normal course of operations. The footage you have requested falls outside the retention window and is no longer available. She had filed the CCTV request on October 12th, 5 days after the relevant footage was recorded on October 9th and 10th. The 7-day retention window should have preserved the footage until October 16th and 17th, respectively. The response was dated October 16th. The timing was either an extraordinary coincidence or an extraordinary lie. She did not believe in coincidences, not in this building, not in this county. She filed a third FOIA request, this time with the Mississippi Attorney General's office, bypassing the county entirely. The request was narrow, the equipment activity log for Unit BC-0447 on October 7th, not the footage, the log, the metadata. The record of whether the camera was powered on, recording, and functional during the time window in question. If the camera had malfunctioned, the equipment log would show it. If the camera had been working, the log would show that too. And the AG's office, unlike the county sheriff's department, had no institutional interest in protecting Kirk Oakley. She mailed the request via certified mail from the post office on State Street. Return receipt requested. Then she drove back to the motel and prepared for the pretrial hearing. But first, she did something else. She drove to the Hinds County Vehicle Maintenance Facility on Medgar Evers Boulevard, a squat cinder block building behind a chain-link fence where the county's fleet vehicles were serviced and stored. She parked across the street in the lot of a laundromat and spent 45 minutes observing the vehicles entering and exiting the facility. She counted 12 dark blue sedans, Ford Interceptors, 2019 through 2022 model years. The county's standard law enforcement vehicle, the same make, model, and color as the sedan that had clipped her bumper on County Road 18. She did not enter the facility, did not photograph the vehicles. She simply counted them, noted the time window, and wrote in the composition book, fleet count, 12 Interceptors, dark blue metallic, observed at maintenance facility, consistent with paint transfer sample. Motor pool access records equals next FOIA target. On the drive back to the motel, she noticed a white sedan in her rearview mirror, 2 cars back, same lane. It had been behind her since the laundromat. She made 3 turns, left, right, left, through residential streets she had memorized during her first week in Jackson. The white sedan made the first 2 turns. On the third, it continued straight, surveillance or coincidence. She could not determine which. But she adjusted her route back to the motel, adding 11 minutes and 4 additional turns to eliminate any following vehicle. She parked at the motel from the opposite direction, entering the lot from the rear entrance. In room 214, she switched SIM cards for the second time and sent a single text. Possible counter surveillance. Adjusting pattern. No change to timeline. The response came in 4 minutes. Noted. Forensic team has preliminary results on target digital infrastructure. We'll brief at next scheduled contact. She switched back. Placed the SIM card in its compartment. Opened the composition book and reviewed every entry she had made since arriving in Jackson. 11 days of observations compressed into 37 pages of handwriting, so small and so dense that the pages looked more like circuit diagrams than prose. Somewhere in this county, in an apartment she had never visited, in front of a computer she had never seen, a man named Vincent Tran was receiving encrypted instructions through a third-party IT consulting firm called Meridian Digital Solutions. His task was described in the contract as legacy database maintenance and archival optimization. The actual work involved adjusting metadata timestamps on body cam files, purging specific CCTV backup logs from the courthouse's server, and modifying the digital timestamps on clerk's office filings to create discrepancies that would, if anyone ever compared the digital records to the physical ones, look like system errors rather than deliberate alterations. Tran was 29 years old, Vietnamese American, a freelance IT specialist who had worked for Meridian for 14 months. He was good at his job. He did not ask questions about the clients. He did not investigate the purpose of the modifications he was instructed to make. He processed the work orders, executed the technical changes, submitted his invoices, and collected payment, which arrived in this case within 48 hours. Government clients typically paid in 60 to 90 days. The speed of payment was unusual, but Tran did not flag unusual. Tran flagged errors. And the instructions he received contained no errors. He did not know Amara Langston existed. He did not know that the files he was modifying were evidence in a civil rights case. He did not know that the DOJ's digital forensics team had already identified his IP address through a routine audit of the courthouse's server access logs. An audit triggered by the FOIA requests that Amara had filed, which had created a paper trail that led directly to the digital modifications he had made. The trap was not designed for Tran. He was infrastructure. The trap was designed for the people who had hired him, the chain of authorization that connected a county courthouse to a consulting firm, to an encrypted communication channel to the judge's chambers where the decision to destroy evidence had been made. The hearing was scheduled for 9 a.m. on October 17th, but the evening of October 16th brought a development that Amara had anticipated but could not control. She was sitting in the motel room, reviewing her notes, when her phone buzzed, a text from Booker. "Heads up. Marsh filed additional discovery materials today at 4 p.m., 200-plus pages. I haven't reviewed them yet. 200 pages of discovery filed at 4 p.m. the day before a 9 a.m. hearing. The tactic was called a document dump, overwhelming the defense with volume at the last possible moment, making meaningful review impossible within the available time. It was not illegal. It was not even uncommon. It was simply the procedural equivalent of bringing a fire hose to a knife fight." Amara texted back, "Can you get me a copy tonight?" 20 minutes later, Booker appeared at her motel room door, the first time he had visited, the first time he had seen where his client lived. He handed her a manila folder, thick enough to serve as a doorstop, and looked around the room with the expression of a man noticing details he had not expected. The bed was made with the precision of a military inspection. Corners folded at 45-degree angles, pillow centered, not a wrinkle on the surface. The toiletries were arranged on the bathroom counter in a single row, ordered by height. The shoes were parallel at the foot of the bed, toes pointing toward the door. "Thank you," Amara said, taking the folder. "I'll review these tonight." "All 200 pages by 9 a.m.? "Yes." Booker opened his mouth to say something, probably something about realistic expectations, about the difference between reviewing and understanding, about the mathematical impossibility of absorbing 200 pages of legal documents in 16 hours. But something in her expression stopped him. She was already opening the folder, already reading. Her eyes moved across the first page with the efficient scan of someone who knew, before looking, what she was looking for. He left. She read. At 2:14 a.m., on page 147 of the discovery materials, she found it. Deputy Oakley's incident report from October 7th, the arrest, included a supplemental form titled Equipment Status Certification. The form required the arresting officer to certify that all recording equipment was functional at the time of the encounter. Oakley had checked the box marked Yes, all equipment operational. His signature was at the bottom, full name, badge number, date, notarized by the precinct's administrative clerk. The same department that told her the body cam had malfunctioned had required its officer to certify, in writing, under penalty of false statement, that the camera was working. 2 documents, 2 contradictory statements. One signed by Oakley, one issued by his department, both in the discovery file. One of them was a lie, and the lie, whichever document contained it, constituted either a false official statement by a sworn officer or a fraudulent FOIA response by a government agency. Either way, someone in the Hinds County Sheriff's Department had committed a crime, and they had put the proof of it on page 147 of a 200-page document dump, filed 16 hours before the hearing, buried between a property inventory log and a vehicle maintenance schedule like a landmine hidden under paperwork. Whether the inclusion was an oversight, a document that should have been withheld but was accidentally included in the volume, or a calculated move by someone inside the system who wanted the contradiction found, she could not determine. But she noted the placement, page 147, not page 2, not page 20, page 147, deep enough that a public defender with 47 cases and 8 minutes of preparation time would never reach it. She photographed the page, time-stamped. Then she photographed the pages immediately before and after it, the property inventory and the vehicle maintenance schedule, for context. She photographed the cover sheet of the discovery packet showing the filing time, 4:07 p.m., October 16th. And she photographed the case number stamp on every page she had flagged. Then she continued reading. Pages 148 through 200 contain nothing of additional value. Routine forms, chain of custody logs for evidence that had already been processed, personnel schedules, standard padding. But page 147 was enough. It was more than enough. It was the kind of document that, in the wrong courtroom, would be ignored, and in the right courtroom, a courtroom that did not belong to Clement Braxton, would end careers. At the pre-trial hearing the next morning, Marsh presented his case with the confidence of a man who had never been contradicted in this courtroom and did not expect today to be different. Your Honor, the state's case is straightforward. The defendant was present on private property in violation of Mississippi Code, Section 97-17-87. She was warned by the property owner through his representative, Deputy Oakley, and refused to leave. The interference charge under 97-9-73 reflects her pattern of non-compliance during the encounter. Braxton nodded. Defense? Booker stood, looked at Amara, sat back down. She was already on her feet. Your Honor, I'm exercising my right to address the court directly on the motion to dismiss. Braxton's eyebrows rose. You have counsel, Ms. Langston. I do, and counsel is aware that I'll be addressing the procedural issues personally. Braxton looked at Booker. Booker raised both hands slightly. The universal gesture of a man who has been overruled by his own client. Braxton sighed. Proceed, briefly. Amara opened her composition book. Not the composition book. The specific page she had prepared, with margin notes and reference documents arranged in the order she intended to present them. Your Honor, the trespassing charge under Section 97-17-87 requires one of two elements, either posted notice on the property or a direct verbal warning followed by refusal to leave. On October 7th, at the time of my arrest, the property at Linden Road had no posted no trespassing signage of any kind. I have photographic documentation. She placed 4 printed photographs on the defense table. Additionally, I was standing on the county road shoulder, public right-of-way, not on private property. The county road marker at the location confirms this. Marsh stood. Your Honor, the arresting officer's testimony. Furthermore, Amara continued, the arresting officer, Deputy Oakley, is also the property owner who filed the trespassing complaint. This dual role constitutes a conflict of interest that calls into question the validity of the arrest itself. I note that the complaint form does not disclose this relationship. The courtroom went quiet. Marsh sat down slowly. Regarding the interference charge under 97-9-73, counsel may want to check the appellate ruling on the case he's relying on. Henderson was reversed on procedural grounds by the Mississippi Court of Appeals in 2020. The standard he's citing was explicitly rejected. She said it from her notes, quietly, without eye contact. Without the theatrical delivery that would have telegraphed confidence and drawn Braxton's ire, she read it the way someone reads a grocery list, matter of fact, unremarkable, devastating. Marsh's face lost color, not dramatically, not the Hollywood pallor of someone caught in a lie, but subtly, a draining of warmth from the cheeks and forehead that only someone watching closely would notice. He had cited Henderson in his filing. He had not checked the appellate history. In Braxton's courtroom, he had never needed to. Braxton's pen tapped the bench, a rapid, irritated rhythm. The court will take the defense's motion under advisement, ruling by end of week. Is there anything else? One more item, Your Honor. Amara turned a page in the composition book. That the defendant, and that's me, requests that the court compel the prosecution to explain the discrepancy between the FOIA response from the Hinds County Sheriff's Department, which states that Deputy Oakley's body cam experienced an equipment malfunction on October 7th, and Deputy Oakley's own equipment status certification form, filed as part of the discovery materials, which certifies that all recording equipment was operational at the time of the arrest. She placed the certification form on the table beside the photographs. Page 147 of the discovery dump filed yesterday at 4 p.m. Silence. The court reporter's fingers had stopped moving. Prescott, at the clerk's desk, was staring at the certification form with the expression of a woman watching a building she had helped construct begin to develop cracks in its foundation. Braxton looked at Marsh. Marsh looked at the form. Marsh looked at Braxton. "The state will address this discrepancy in its supplemental filing," Marsh said. "See that you do." Braxton's voice was tight, controlled, the voice of a man who was angry, but not at the person he should have been angry at. "Court is adjourned." The gavel came down. Everyone stood. Braxton exited through the side door. In the hallway, Booker caught Amara's arm, gently, not like Calloway, but with the urgency of a man who had just watched something he did not understand and needed answers. "Where did you learn to do that?" "Do what?" "The appellate site, the equipment status form, the whole thing. You read that room like you've done it 100 times. Amara removed his hand from her arm, not roughly, not coldly, with the measured precision of a woman who controlled the perimeter of her own body the way she controlled the perimeter of her case. "Has the chain of custody on the body cam footage been established?" she asked. Booker stared. "The chain of—" "Ms. Langston, most defendants don't know what chain of custody means. Most defendants haven't had their cases documented by the same person who arrested them and filed the complaint." She picked up her backpack. "Can you file a supplemental motion for me by end of day? I'll draft it tonight." "You'll draft it." "I'll draft it." He watched her walk down the hallway toward the courthouse exit. She passed Prescott's window without looking, past Calloway's security station without stopping. She was 4 steps from the metal detector when she heard the footsteps behind her, fast, heavy, purpose-built. Before she could turn, a hand closed around her elbow and pulled, spinning her sideways into the wall beside the security desk. Her backpack hit the plaster first, then her shoulder, then the back of her head, a dull thud that rattled her vision for half a second. Calloway stood over her. His face was red. His breathing was controlled, not panicked, not impulsive, but the deliberate exhalation of a man who had decided to act and was managing the performance. "You dropped something." He held up a pen. A courthouse pen, the kind available in cups on every counter in the building. "Can't have people walking out with county property." She looked at the pen, looked at Calloway, looked at the 2 bailiffs at the desk who were studying their clipboards with the concentrated attention of men who had decided not to see what they were seeing. "That's not my pen. It was in your hand when you walked past my desk." He leaned closer. His voice dropped below the ambient noise of the security station. "You made the judge look bad in there. People who make the judge look bad in this building tend to have a rough time getting through security. Every single day." He released her elbow, placed the pen on the counter, stepped back into his position behind the desk, with the fluid economy of a man returning to a choreography he had performed many times. Amara straightened her backpack, touched the back of her head. No blood, but a knot was already forming above the base of her skull. She walked through the metal detector, out the doors, down the steps. In the parking lot, she sat in her Nissan and inventoried the damage. Elbow, red marks from the grip, already fading. Shoulder, sore but functional. Head, tender, no laceration. Combined with the ribs from the hit and run and the cut above her eye, her body was accumulating a geography of violence that mapped precisely onto the geography of this courthouse. Each injury connected to a person, a location, a timestamp. She photographed the marks on her elbow, time-stamped, wrote in the composition book, "Calloway, physical contact, 3rd incident, pushed into wall, threat delivered, future access, witnesses present, uninvolved, pen pretext fabricated." Then she started the car and drove to the motel. She did not look back, but she felt it. The weight of attention from inside the building, the gaze of a system that had processed her as an error and was now, for the first time, uncertain whether she was the error or the correction. If this story is making your heart race, wait until you see what she pulls out next. But only if you're subscribed. Hit that button now, because the next part changes everything. At the motel that night, she reviewed the discovery materials for the 2nd time, marking pages with small adhesive tabs she had purchased at the pharmacy next door. She organized her FOIA responses chronologically in a folder she kept not in the motel room, where they could be accessed if the room was entered in her absence, but in the trunk of her Nissan beneath the spare tire cover, in a waterproof bag she had bought at the same pharmacy. She was building a structure, not a legal defense. That was Booker's job, at least on paper, but a documentation architecture. Every interaction, every filing, every denial, every timestamp discrepancy, every physical contact, every whispered rumor, all of it cataloged, dated, cross-referenced, and stored in locations that could not be compromised by any single point of failure. She had been building structures like this for 12 years. It was what she did. It was, in a fundamental sense, who she was. But the people in the Hinds County courthouse did not know that yet. In 72 hours, they would. Not all of them. Not the full truth. Just enough to change the direction of the current. Just enough to make the system that had been grinding her down begin, for the first time, to grind against itself. But that was for part 2. For now, she placed the composition book under her pillow, lay on her back, pressed her hand against her bruised ribs, and counted breaths. Outside, the interstate hummed with trucks heading north, carrying cargo through the Mississippi darkness toward destinations they would reach by morning. Inside room 214, the woman who had been arrested, charged, threatened, hit, dismissed, and humiliated, closed her eyes and did not sleep. She was waiting. And what she was waiting for, what she had driven 800 miles and endured 22 days to set in motion, was already closer than anyone in the Hinds County courthouse could possibly imagine. The response from the Mississippi Attorney General's office arrived on October 20th, 3 days after the pre-trial hearing, 6 days before the trial date, in a plain white envelope with a state seal in the corner and the kind of bureaucratic neutrality that disguised the explosive nature of what was inside. Amara opened it at the motel room desk, standing, because sitting put pressure on her ribs, and she had learned over the past week to manage the pain by managing her posture. The envelope contained 2 pages. She read the first page twice. Then she read the second page 3 times. The first page was a cover letter, standard language. In response to your request, dated October 12th, pursuant to the Mississippi Public Records Act, Section 25-61-1 at say Q. And the Office of the Attorney General provides the following responsive document. The second page was the document itself. Equipment Activity Report, Hinds County Sheriff's Department, Unit BC-0447, assigned to Deputy K. Oakley. Date, October 7th. Time window, 1400 hours to 1530 hours. Status, active. Battery level, 94%. Storage capacity, available. 62% remaining. Recording mode, continuous. Malfunction flags, none. She read the 6 lines again. Then she placed the document on the desk and stood very still for approximately 10 seconds. The kind of stillness that was not calm, but was instead the physical manifestation of a mind processing information at a speed that required the body to stop moving in order to keep up. The body cam had been working, active, recording. 94% battery, no malfunction flags, continuous recording mode. The footage existed, or had existed, during the exact time window of her arrest. The Hinds County Sheriff's Department had told her the camera malfunctioned. Deputy Oakley had certified, in writing, that the camera was operational. The AG's equipment log confirmed the camera was operational. 3 documents, 2 of them agreed. One of them, the department's FOIA response, was a lie. The footage had not malfunctioned. It had been destroyed, or hidden, or altered, and somewhere in the chain between the camera on Oakley's chest and the server where the footage was stored, someone had made the decision to make it disappear. She photographed the AG's response, time-stamped, placed it in the waterproof folder in the trunk of her Nissan, beside the other documents she had been accumulating. The FOIA denial, the equipment status certification from the discovery dump, the incident report from the hit and run, the photographs of the fence line, the photographs of the paint transfer. The folder was getting thick. The case was getting close. She switched SIM cards and made a call. Not a text this time, but a voice call to the Washington number. It lasted 4 minutes and 17 seconds. She spoke in short, precise sentences, pausing between each one to allow the person on the other end to take notes. When she hung up, she switched SIM cards back and drove to the Chevron station on County Road 18. The station sat 0.3 of a mile from the spot where her Nissan had been run off the road 6 days earlier. It was a small operation, 2 pumps, a convenience store with a hand-lettered sign advertising boiled peanuts and live bait, and a single security camera mounted on a pole above the entrance, aimed at the parking lot and the road beyond. The owner was a man named Hosea Clement. He was 71 years old, with hands that showed 5 decades of manual labor, and eyes that held the particular clarity of someone who had watched his county change, and not change, for longer than most people had been alive. He was sitting behind the counter reading a newspaper when Amara walked in. "Help you? I was in a car accident on the County Road 18 last week, about 1/3 of a mile east of here. I was wondering if your security camera might have captured any footage from that evening." Hosea folded his newspaper slowly, studied her face, the butterfly strips above her eye, the careful way she held her left arm against her ribs. He had seen the accident report in the county police blotter. Single vehicle, driver lost control, case closed. What night was that? October 14th, around 9 p.m. He nodded, reached below the counter and produced a laptop that looked older than some of the students at the county high school. He opened it, navigated to a folder with the unhurried confidence of a man who maintained his own systems, because he didn't trust anyone else to do it, and scrolled through a list of video files organized by date. Camera's been there 12 years. Ain't nobody ever asked for footage before. He found the file. October 14th. He scrubbed through the timeline. Empty road, a pickup truck at 8:47, empty road, until he reached 21:04. A dark blue sedan appeared at the right edge of the frame, traveling east on County Road 18. No headlights. Moving fast, the kind of speed that made the vehicle blur slightly in the low-resolution footage. The sedan crossed the camera's field of view in approximately 3 seconds and disappeared off the left edge, heading toward mile marker 4, toward Amara. The timestamp read 21:04:11, 4 minutes and 47 seconds before her 911 call. "That the car?" Hosea asked. "Can you see the plate?" He zoomed in. The resolution was poor. 12-year-old camera, nighttime, no infrared. But 3 characters of the rear plate were legible, the first 3. Letters and numbers that Amara wrote in her composition book without comment. "I can put that on a drive for you," Hosea said. He was already reaching for a USB stick in the drawer. "Anything else you need?" "Just the footage, and I appreciate your help, Mr. Clement." He handed her the USB drive. She reached for her wallet. He raised a hand. "No charge. Somebody runs a woman off the road at night with their lights off. That ain't an accident." He paused, looked at her with the directness of a man who had survived 7 decades in Mississippi by reading people accurately. "You be careful out there, Ms. Langston." "Ms. Langston," he nodded once. "You be careful." She left the Chevron station and sat in the Nissan for 3 minutes, looking at the USB drive in her palm. The plastic was warm from Hosea's hand. 12 years of footage on a camera no one had ever asked about, in a station no one considered important, on a road where a woman had been run off the asphalt, and the official report said she'd lost control on a curve. Hosea had not asked why she wanted the footage, had not demanded identification, had not called the sheriff's department to verify her story. He had simply looked at the butterfly strips on her face and the way she held her ribs and decided that a woman asking for help deserved to receive it. The simplicity of the gesture, its directness, its absence of bureaucratic process, stood in such stark contrast to every other interaction she had experienced in Hinds County that it momentarily disrupted the professional detachment she had maintained for 2 weeks. She sat in the car and allowed herself 5 seconds of something that was not quite emotion, but was adjacent to it. The kind of internal shift that happens when a person who has been absorbing institutional hostility for 14 consecutive days encounters unexpected kindness, and the contrast illuminates exactly how much hostility they have been absorbing. 5 seconds. Then she started the engine. She drove back to the motel. In the parking lot, she sat in the Nissan and looked at the USB drive in her hand. 3 characters of a plate. Not enough for a definitive match. But the vehicle's make and color, dark blue, sedan, sized consistent with a Ford Interceptor, matched the county's fleet vehicles. The timestamp placed it on the road 4 minutes before the collision, traveling in the direction of the impact. It was not proof, it was proximity. And in a case built on pattern of behavior, pattern of bias, pattern of evidence destruction, proximity was another data point in a constellation that was beginning to form a recognizable shape. She added the USB drive to the folder in the trunk. The next 3 days, October the 21st through 23rd, Amara spent at the county library, building a statistical portrait of Judge Braxton's courtroom that would have made a graduate researcher nervous and a federal investigator very interested. She pulled every publicly available docket from Braxton's courtroom for the past 3 years, 340 cases. She categorized each one by 6 variables: defendant's race, charge type, bail amount, continuance requests and outcomes, plea versus trial, and sentence length. The work was tedious. The docket system was paper-based for anything older than 18 months, requiring her to request physical files from the clerk's office, which meant interacting with Prescott, which meant delays, obstructions, and the particular slow-motion hostility of a woman who had decided that helpfulness was a currency she would not spend on Amara Langston. On one of these trips to the clerk's window, Prescott escalated beyond obstruction into something more personal. Amara had requested 3 case files from 2022, public records available to any citizen. Prescott studied the request form for a full minute, then pushed it back across the counter. These files are archived. Archived files require a written request with a stated purpose: policy. What's the policy number? Prescott's smile thinned. It's administrative, internal. I'd like to see the written policy, please. It's not posted for public access. Then how would a member of the public know to comply with it? Prescott leaned forward. Her voice dropped to a pitch designed to carry intimacy and threat in equal measure. Ms. Langston, I've been working this window for 14 years. I don't need a trespassing defendant telling me how to do my job. If you have a complaint, the suggestion box is in the lobby. Otherwise, come back with a proper request form, the yellow one, not the white one. The white one is for current cases only. There was no yellow form. Amara had reviewed every form available in the public access area: white forms for current records, blue forms for certified copies. No yellow form existed. Prescott was manufacturing a bureaucratic obstacle with the same precision that the rest of the system manufactured legal ones. "Thank you for your help," Amara said, and left. She returned the next day with a blue form, requesting certified copies of the same 3 files, which carried a processing fee she paid by money order, and received the files within 40 minutes. Prescott could not deny a certified copy request without creating a paper trail that would document the denial. The blue form had a tracking number. The yellow form did not exist. The difference between the two, between a request that could be refused in silence and a request that would be documented if refused, was the difference between institutional discretion and institutional accountability. Amara filed the blue form and noted in her composition book, Prescott invented yellow form requirement. No such form exists. Archived files released via certified copy request, blue form, within 40 minutes. Selective enforcement of non-existent policy equals obstruction pattern, but Amara had patience. She had been trained in patience the way other people were trained in martial arts, through repetition, discomfort, and the understanding that the ability to wait was itself a weapon. The data told a story that numbers tell better than narrative. Black defendants in Braxton's courtroom received an average bail 3.2 times higher than white defendants charged with equivalent offenses. Continuances were granted to white defendants at a rate of 78%. For black defendants, the rate was 23%. White defendants who went to trial received an average sentence 14% below the statutory guideline. Black defendants who went to trial received an average sentence 31% above the guideline. The disparity was not hidden. It was not subtle. It was the statistical equivalent of a neon sign, visible to anyone who bothered to count. But no one in Hinds County had bothered to count, because counting required access to the dockets, and access to the dockets was controlled by Prescott. And Prescott controlled access the way a border guard controls a checkpoint, selectively, strategically, and with the full backing of the authority she served. Amara compiled the data in her composition book, 47 pages of handwritten analysis, charts drawn with a ruler, percentages calculated by hand and verified twice. She did not use the library's computers for this work. Digital footprints could be traced, and she was not ready to be traced. Not yet. On the afternoon of October 23rd, as she was leaving the courthouse after another fruitless interaction with Prescott over a file request, she passed the clerk's filing window for the last time that day. Jonah Wyatt was alone at the counter. Prescott had stepped away. Break, phone call, or the simple exercise of disappearing when Amara appeared, a tactic that allowed her to deny service without the inconvenience of refusing it in person. Amara placed her file request form on the counter. Jonah picked it up without speaking. His eyes scanned the form, case number, date range, document type, and then moved to her face. He held her gaze for approximately 2 seconds, which was 2 seconds longer than he had ever looked at her before. Ms. Langston. Not ma'am, not defendant. Not the case number that Prescott used when she referred to Amara in the third person within earshot. Her name. Spoken quietly, with a weight that was disproportionate to the volume. The weight of recognition, of attention, of a young man who had been watching from his corner of the clerk's office for 3 weeks and had decided, in this moment, to let her know that he had been watching. She nodded, said nothing. Neither did he. He processed the file request in 4 minutes, a speed that Prescott had never achieved in 43, and slid the documents across the counter. Their hands did not touch, their eyes did not meet again. He returned to his filing. She returned to the gallery, but something had shifted. A molecule of allegiance, invisible and unmeasurable, had detached itself from the courthouse's institutional structure and attached itself to Amara Langston. She could feel it the way you feel a change in barometric pressure, not as a sensation, but as an awareness that the atmosphere had altered. That evening, a manila envelope appeared under the door of Dale Booker's office on the 2nd floor of the county legal aid building. No name on the envelope, no return address, no postage. Hand-delivered, slipped under the door sometime between 5:15 p.m. when Booker left for the day and 7:40 a.m. the next morning when he returned. Inside, 3 printouts. The first printout showed the digital docket entry for Amara's discovery motion, the one she had filed on October 8th and Prescott had lost. The digital timestamp read 9:14 a.m., but the paper filing receipt, which Amara had photographed and which matched the physical copy in her possession, showed a timestamp of 8:47 a.m., a 27-minute discrepancy. The second printout showed the digital docket entry for a motion to suppress, filed by a different defendant in a different case 3 months earlier, with a similar discrepancy. Digital timestamp, 10:02 a.m. Paper receipt, 9:38 a.m., 24 minutes. The third printout showed the digital docket entry for a bail reduction request. Again, different defendant, different case 5 months earlier, with the same pattern. Digital timestamp, 11:47 a.m. Paper receipt, 11:11 a.m., 36 minutes, 3 filings, 3 discrepancies, 3 cases in which the digital record had been altered after the physical filing. The timestamps pushed forward by 20 to 36 minutes, creating the appearance that the filings had been submitted later than they actually were. Late enough in each case to justify a denial based on timeliness. No signature on the printouts, no note, no explanation, just paper, just evidence. Just the quiet work of someone who had access to both the digital system and the physical files and who had decided, for reasons the printouts did not explain, to make the discrepancy visible. Booker called Amara at 8:15 the next morning. His voice carried the particular confusion of a man holding something he did not understand and was not sure he wanted to. Someone left an envelope under my door, 3 printouts, docket entries that don't match the paper filings. He paused. Ms. Langston, I've been practicing in this courthouse for 11 years. Who would do this? Can I see them? She met him in the parking lot behind the legal aid building. He handed her the envelope with the careful grip of a man transferring a responsibility he was not equipped to carry. She studied the printouts for 60 seconds, longer than she needed, but consistent with the reaction of someone seeing the information for the first time. These timestamps don't match the physical filings. I know, that's what I just said. Can I keep these? Booker hesitated. The printouts were evidence of tampering, evidence of obstruction, evidence of a pattern that extended beyond Amara's case into the courthouse's fundamental record-keeping system. Keeping them was the right thing to do, but in Hinds County, the right thing and the safe thing occupied different zip codes. "Keep them," he said, "and Ms. Langston, be careful who you show them to." She placed the printouts in the waterproof folder. The folder was now thick enough that the zipper strained. She added a label to the folder's exterior, a small adhesive tag with a date range and a case number that was not her own. The case number was a DOJ internal reference. It would mean nothing to anyone who found the folder. It would mean everything to the people who were waiting for her to deliver it. The hit-and-run investigation closed on October 25th. Amara learned about it not from Oakley, who had no obligation to notify her, and certainly no inclination, but from the county police blotter published in the Jackson Clarion Ledger. Case number HC-2024-1847. Investigating Officer Deputy K. Oakley. Finding: single vehicle accident, driver lost control on curve. Insufficient evidence to identify a second vehicle. Disposition: no further action. Case status: closed. She read the blotter entry at the library's newspaper station, sitting in the chair Gerald had unofficially reserved for her by placing a small reserved card on the table each morning before she arrived. She read it twice. Then she placed the newspaper back on the rack and returned to her desk, where the composition book lay open to a page of statistical analysis she had been compiling. She wrote 2 words beneath the analysis: as expected. No mention of the paint transfer on her bumper, no mention of the tire marks in the opposite lane, no mention of her photographs, submitted to Oakley at the scene, logged on her phone with timestamps that contradicted his report. No mention of the gas station footage, which she had not submitted to Oakley because submitting evidence to the man she suspected of being involved in the incident would be the operational equivalent of handing a suspect the murder weapon and asking him to dust it for prints. The case was closed. The evidence was in her trunk, and the distance between the two, between the official narrative and the documented reality, was the distance the federal investigation would eventually need to cross. They buried the evidence. They closed the case. They thought she was out of options. But the woman they dismissed as a trespassing defendant was about to show them what real authority looks like. Stay tuned. On October 26th, the day before the trial, Amara did not go to the courthouse. She did not go to the library. She did not leave the motel room. She spent the morning organizing. The waterproof folder came in from the trunk. Its contents were spread across the bed, not the desk, because the desk was too small for the architecture she needed to construct, and arranged in chronological order from left to right, top row to bottom row. Row 1, the arrest. Photographs of the fence line. Photographs of the road marker. The 911 dispatch log. The booking form. The bail receipt. Row 2, the courthouse. Filing receipts with timestamps. Prescott's denial. The refiled motion. Photographs of Callaway's security checks. Notes on the gossip campaign. The composition book entries documenting each physical contact. Dates, times, durations, locations, witnesses. Row 3, the hit and run. Photographs of the tire marks. Photographs of the paint transfer. The 911 call log. Oakley's incident report. The closing report from the blotter. The gas station USB drive. Row 4, the FOIA responses. The county's denial. Equipment malfunction. The AG's equipment log. Camera active, no malfunction, 94% battery. Oakley's equipment status certification. All equipment operational. 3 documents, 2 truths, 1 lie. Row 5, Jonah's printouts. 3 docket entries altered after filing. 27 minutes, 24 minutes, 36 minutes. Pattern established. Row 6, the statistical analysis. 340 cases. Bail disparity. 3.2 times. Continuance disparity, 78 versus 23%. Sentencing disparity, 14% below guideline versus 31% above. She stood at the foot of the bed and looked at the rows the way an architect looks at a blueprint, not as individual pieces, but as a structure, a system of interlocking evidence that, assembled correctly, would support the weight of what she was about to build. Then she repacked the folder, placed it in the trunk, returned to the room. Switched SIM cards, made her second voice call. This one lasted 11 minutes. She spoke more than she had in the previous call. Complete sentences, references to specific exhibits, a timeline she recited from memory because the composition book was on the bed and she did not need it. She had memorized every entry. The voice on the other end asked one question. She answered it. The voice said 3 words. Tomorrow, 9 a.m. She switched SIM cards back, placed the second SIM in its compartment, sat on the edge of the bed, and pressed her hand against her ribs, which had downgraded from sharp pain to a persistent ache that she had incorporated into her daily functioning, the way a building incorporates a load-bearing wall, invisibly, structurally, without complaint. She opened the composition book to the back cover. The back cover was thicker than the front, noticeably thicker, though not conspicuously so. She ran her thumb along the edge and felt the outline of the laminated card stored inside, between the cover's layers. She had carried it for 22 days. Through the arrest, through the booking, through the security checks, through Calloway's hands on her arm and the airbag against her face and the metal detector's electronic gaze. No one had found it. No one had looked. She closed the book, placed it under the pillow, did not sleep. October 27th, 9 a.m., courtroom 3. The morning arrived with the institutional hum of a building preparing to perform its daily function. The sound of fluorescent lights warming, doors opening, coffee being poured into paper cups by people who had been doing this for decades and would continue doing it for decades more, regardless of what happened in any individual courtroom on any individual day. Amara dressed at the motel with the same precision that had defined every morning for 3 weeks, shirt buttoned from the bottom up, shoes parallel. Composition book in the left pocket, but this morning she added one step to the routine. She opened the composition book to the back cover and pressed her thumb against the laminated card inside. Still there, still hidden, still waiting. She looked at herself in the bathroom mirror. The scar above her eye was pink and permanent, a souvenir from a county road and a sedan that no one would officially acknowledge. Her ribs had graduated from sharp pain to dull ache. Her arms were clean. Calloway's fingerprints had faded weeks ago, though the memory of his grip remained as vivid as a photograph. She closed the composition book, zipped the backpack, left the room key on the desk. She would not be coming back to room 214. Amara passed through the metal detector at 8:43. Calloway was at his station. He looked at her. She looked at him. He did not search her bag, did not touch her arm, did not block her path. Something in her expression, or something in the air that morning, a charge he could feel but not identify, made him step aside without performing the ritual that had defined their interactions for 3 weeks. She walked to the elevator, pressed the button, checked her watch. 8:44, 16 minutes. In the elevator, she was alone. She pressed the button for the 3rd floor and stood with her back against the wall, watching the numbers climb. At the 2nd floor, the doors opened. Prescott stepped in, carrying a stack of files and a coffee cup with a lipstick stain on the rim. She saw Amara and froze. A half-second of recognition, then recovery, then the performative indifference that had become her default expression. "Morning," Prescott said. She pressed the button for the 3rd floor, already pressed, and stood on the opposite side of the elevator. The distance between them was 4 feet. The silence was thicker. Amara said nothing. The elevator rose. The doors opened. Prescott exited first, walking quickly, heels clicking on the marble floor. Amara followed at her own pace. In 9 minutes, the distance between them would collapse entirely. In courtroom 3, the morning docket was light. 3 cases before Amara's, each processed with Braxton's characteristic efficiency. She sat in the back row of the gallery, her seat, the one she had occupied every day for 3 weeks until the geography of belonging had bent, however slightly, to accommodate her presence. The composition book sat on her lap, closed, its thicker back cover resting against her thigh. Booker arrived at 8:52. He sat beside her in the gallery and leaned close. "I got a call this morning from someone at the AG's office. They wanted to confirm the case number and the trial date. I didn't give them your number. I don't know how they got the case information." "They have the case information. How?" She did not answer. Booker studied her profile. The cut above her eye, now a thin pink scar. the composure that had never broken, not once, in 3 weeks of escalating hostility, the way she held the composition book with both hands, thumbs resting on the edge of the back cover. "Ms. Langston, what's going to happen in there?" "Justice," she paused. "Partial justice, the kind that takes months to finish and years to feel." At 9:03, the bailiff called the case. Case number 24783, State of Mississippi versus Langston. Trespassing, single count. Interference with law enforcement operations, single count. Defendant is present with counsel. Amara stood. Booker stood beside her. Across the aisle, ADA Fielding Marsh arranged his files with the precision of a man who had prepared his closing argument before the trial began and saw no reason to deviate from the script that had delivered victories in this courtroom for 2 unbroken years. Braxton presided. He looked at Amara the way he had looked at her on the first day, the fluorescent discs of light on his reading glasses, the permanent lines of authority, the gaze that sorted defendants into categories before they spoke. She was still in the same category, still the error to be corrected, still the problem to be processed. He did not know that in approximately 7 minutes, his courtroom would cease to be his courtroom. "Counsel, is the prosecution ready to proceed?" Marsh stood. "The state is ready, Your Honor." "Defense?" Amara looked at Booker. Booker raised both hands slightly, the same gesture from the arraignment, the surrender of a man who had been overruled by his own client and had made peace with it. "The defense is ready, Your Honor. Ms. Langston will be addressing the court directly on the initial motion." Braxton's jaw tightened. "I've allowed this once, Ms. Langston. Don't make me regret the courtesy. Proceed." She opened the composition book, not to a prepared page, to the back cover. Her thumb found the edge of the laminated card and paused. "Your Honor, before the court proceeds with the trial, I need to make a disclosure." "A disclosure?" Braxton's tone was flat, dismissive, the tone of a man who had heard every tactic, every delay, every procedural gambit that defendants and their attorneys could devise, and who had decided, before she finished her sentence, that whatever she was about to say would be denied, overruled, or ignored. "Yes, Your Honor, a disclosure that will affect the court's jurisdiction over this matter." Marsh looked up from his files. Jurisdiction was a word that prosecutors heard the way surgeons hear the word complication. It meant the plan was about to change. At the back of the courtroom, the doors opened. 2 people entered. The first was a woman in a dark navy suit, tailored, professional, the kind of suit that announced federal authority without requiring a badge. Her name was Diane Colfer. She was the regional supervisor for the DOJ's Civil Rights Division, Southern District. She had flown from Washington on the 6 a.m. flight that morning and had driven from the Jackson airport directly to the courthouse. The second was a man in a gray suit carrying a manila folder with a blue federal court seal on the cover. He was a process server with the United States Marshals Service. They walked down the center aisle of the courtroom, past the gallery, past the bar, past the seats where attorneys and families and witnesses sat, and stopped at the front row. Colfer sat down. The process server remained standing. Braxton watched them enter. His pen stopped moving. His reading glasses slid half an inch down his nose, and he did not push them back. "Your Honor." Amara's voice was level, quiet. The same quiet that had carried her through 3 weeks of courtroom observation, security checks, physical confrontations, and a car being run off a county road in the dark. "My name is Amara Langston. I am a senior trial attorney with the United States Department of Justice, Civil Rights Division, Criminal Section." She removed the laminated credential from inside the composition book's back cover, placed it face up on the defense table. The DOJ seal caught the courtroom's fluorescent light, blue and gold, federal authority rendered in laminate and plastic, 22 days hidden inside a composition book that no one had thought to examine beyond its pages. "I have been present in this courthouse for the past 22 days, pursuant to a preliminary investigation, authorized under 34 U.S.C. Section 12601, regarding a pattern or practice of conduct by officials of Hinds County that deprives individuals of rights protected by the Constitution." The courtroom did not gasp. Courtrooms in real life rarely gasp. What happened was quieter and more devastating. A simultaneous intake of breath from 40 people who understood in the same instant that the architecture of the room had just inverted. The defendant was the investigator. The judge was the subject. The courtroom was the evidence. Braxton's hands gripped the edge of the bench. His knuckles whitened. His mouth opened, closed, opened again. This is my courtroom. His voice cracked on the possessive. You have no authority to... Diane Colfer stood. She did not approach the bench. That would require permission from the presiding judge, and the presiding judge was about to lose that authority. She spoke from the front row, her voice carrying the practiced projection of a woman who had delivered federal notifications in hostile courtrooms across 11 states. Your Honor, the United States Department of Justice has filed a complaint in the United States District Court for the Southern District of Mississippi. She nodded to the process server, who stepped forward and placed the manila folder on the clerk's desk. On Prescott's desk, 6 inches from Prescott's hand. Prescott did not touch it. The complaint is styled United States versus Hinds County, Mississippi, Judicial District Operations. It names you, Your Honor, as a respondent, along with Deputy Kirk Oakley, ADA Fielding Marsh, and the Hinds County Sheriff's Department. Marsh was on his feet. Your Honor, the prosecution objects to, under 28 U.S.C. Section 455, Amara continued, her voice cutting through Marsh's objection with the precision of a scalpel through gauze. You are required to recuse yourself from any proceeding in which your impartiality might reasonably be questioned. That includes any proceeding in which you are a named respondent in a federal civil rights complaint. I would recommend consulting counsel before saying anything further on the record, Your Honor. The court reporter's fingers moved without pause, every word recorded, every syllable preserved. The machine did not care about jurisdiction or authority or the 22 years Braxton had spent on this bench. It captured what was said, and what was said could not be unsaid. Braxton looked at the credential on the defense table, looked at Colfer, looked at the federal complaint on Prescott's desk, looked at Amara. This will be challenged, he said. His voice had dropped, not in register, but in conviction, the way a building's foundation drops when the ground beneath it shifts. This will be appealed. This is federal overreach, and I will, Your Honor. Colfer's voice was polite, firm, and completely devoid of negotiation. Recusal is mandatory, not discretionary. Any further rulings you issue in this matter, or in any matter, while you are a named respondent in an active federal complaint, are subject to automatic reversal and may constitute obstruction. I strongly advise you to step down from the bench and contact your personal attorney. Silence. The clock on the courtroom wall, a round institutional clock with black hands and a white face, ticked through 8 seconds of silence. 8 seconds in which 22 years of unchallenged authority met the immovable reality of federal jurisdiction. Braxton removed his reading glasses, placed them on the bench, stood up, and stepped down. He did not speak again. He walked through the side door, the same door he had used to exit the courtroom every day for 2 decades, and closed it behind him. The sound of the latch engaging was the quietest noise in the room, and the loudest. Senior Judge Lorraine Hatchett, brought in from an adjacent district, notified at 6:30 a.m., briefed during the drive to Jackson, assumed the bench within the hour. She was 64 years old, appointed by a governor 2 administrations removed from the current one, with a reputation for procedural rigor that made her unpopular with attorneys who relied on institutional goodwill, and very popular with attorneys who relied on the law. The court notes the recusal of Judge Braxton and the assumption of jurisdiction by the undersigned, Hatchett said. Her voice was dry, precise, entirely absent of drama. Ms. Langston, you're a DOJ attorney. Is the United States moving to dismiss the charges against you? The United States is not a party to this proceeding, Your Honor. I'm appearing in my capacity as the defendant. The charges were filed by the state of Mississippi through ADA Marsh. What I am entering into evidence is a series of exhibits relevant to the defense's motion to dismiss for lack of probable cause and prosecutorial misconduct. Hatchett nodded. Proceed. Amara opened the waterproof folder. 22 days of documentation, organized by category, labeled with exhibit letters, arranged in the order she had rehearsed at the motel the night before. Exhibit A, Equipment Activity Report from the Mississippi Attorney General's Office, responsive to a FOIA request filed October 12th. The report confirms that Deputy Oakley's body cam, Unit BC-0447, was active and recording during the time window of my arrest on October 7th. Battery at 94%. No malfunction flags. This directly contradicts the Hinds County Sheriff Department's FOIA response, which claimed the footage was unavailable due to equipment malfunction. She placed the document on the defense table. The court reporter's keys clicked. Exhibit B, still frames captured from security camera footage at the Chevron station on County Road 18, recorded on October 14th at 21:04 hours. The frames show a dark blue sedan traveling east without headlights, 4 minutes before my vehicle was struck from behind at mile marker 4. The vehicle's make and color are consistent with a Ford Interceptor, the model exclusively purchased by Hinds County for law enforcement use. Forensic comparison of paint transfer from my vehicle's rear bumper, she placed the photographs on the table, is consistent with factory paint used on 2019 through 2022 Ford Interceptors. Marsh stood. Your Honor, the relevance of a traffic accident to a trespassing charge is overruled. Hatchett did not look at Marsh. Continue, Ms. Langston. Exhibit C, 3 docket entries from the Hinds County Clerk's filing system, provided anonymously to defense counsel on October 24th. She placed Jonah's printouts on the table. Each entry shows a discrepancy between the digital timestamp and the physical filing receipt. In each case, the digital record was altered after the initial filing. The timestamp pushed forward by 20 to 36 minutes, creating the appearance of late filing. These documents were received in sealed condition and have been preserved in evidence bags since receipt. Chain of custody is documented. Prescott, at the clerk's desk, had stopped breathing. Her hands were flat on the desk's surface, a mirror of the posture Amara had held at the defense table 3 weeks earlier, though for very different reasons. She was staring at the printouts with the expression of someone who recognized their own architecture being used as evidence against them. Exhibit D, digital forensic analysis conducted by the DOJ's Electronic Crimes Section. Amara placed the final document on the table, the thickest, the most technical, the one that connected the individual pieces into a systemic pattern. Analysis of the Hinds County Courthouse's server access logs identified unauthorized modifications to body cam metadata files and CCTV storage logs. The modifications were executed remotely from an IP address registered to Meridian Digital Solutions, LLC, a private IT consulting firm contracted by Hinds County on October 9th, 2 days after my arrest. The contract was executed under the description Legacy Database Maintenance and Archival Optimization. Invoice records show payment was processed on October 23rd, 48 hours after the hit-and-run incident, coinciding with the purging of CCTV backup files that would have documented Bailiff Calloway's physical interactions with me at the security checkpoint. She paused. Let the courtroom absorb the timeline. October 7th, arrest. October 9th, contract executed. October 14th, hit and run. October 23rd, invoice paid, CCTV purged. The sequence was not a coincidence. It was a campaign. The timing of contract execution, the specific files targeted for modification, and the velocity of payment are consistent with an organized effort to destroy evidence of civil rights violations committed under color of law. Marsh was standing again. His face had drained of the confidence that had defined his posture in this courtroom for 2 years. He looked like a man standing in a building during an earthquake, upright but uncertain of the floor. Your Honor, the defense is presenting material that is not relevant to the charges before the court. This is a simple trespassing case, not a... Simple. Hatchett's voice was flat. She removed her reading glasses and looked at Marsh with the expression of a judge who had seen enough. ADA Marsh, the added charge of interference under Section 97-9-73 appears to lack factual foundation based on the materials presented today. The defendant cooperated with the arrest. She provided identification. She did not resist. The arresting officer's own report does not describe physical obstruction or resistance. On what basis was this charge filed? Marsh opened his folder, closed it, opened it again. The defendant questioned the deputy's authority during the encounter. She refused to comply with his verbal direction to vacate. She was standing on a county road shoulder, on public land. Questioning an officer is not interference, it is a constitutionally protected activity. Hatchett made a note. The court dismisses the interference charge. The trespassing charge will be addressed pending the prosecution's response to the evidentiary discrepancies raised by the defense. ADA Marsh, you have 14 days to file a supplemental brief. She turned to Oakley, who was seated in the witness area. Present as a prosecution witness, still in uniform, still wearing the badge that had authorized 22 days of institutional violence against a woman who turned out to be the federal government. Deputy Oakley. Hatchett's voice carried no warmth. You are served. The IA liaison from the Hinds County Sheriff's Department, a woman in plain clothes who had entered the courtroom during Amara's presentation of exhibits and had been standing against the back wall, stepped forward and handed Oakley an envelope. Inside, a suspension order, effective immediately, without pay, pending internal investigation into conduct during the arrest of October 7th, the incident report of October 14th, and the equipment status certification discrepancy. Oakley took the envelope, opened it, read it. His face did not change. The face of a man who had practiced not reacting, but this time the practice failed. His lower lip trembled for half a second before his jaw locked it in place. He stood, removed his badge, placed it on the bench in front of him, walked out of the courtroom through the gallery doors, past Amara, past Colfer, past the court reporter, whose keys had not stopped moving, and disappeared into the hallway. Hatchett addressed the remaining items with the efficiency of a judge who understood that the real proceedings, the federal investigation, the administrative reviews, the months of depositions and document production, were just beginning, and that her role today was to set the table, not serve the meal. The court notes for the record that a federal complaint has been served on Judge Braxton, Deputy Oakley, ADA Marsh, and the Hinds County Sheriff's Department under 34 U.S. C-Section 12601. A cooperation agreement is being negotiated with the individual identified as the contractor responsible for the digital record alterations, a Mr. Vincent Tran, operating through Meridian Digital Solutions. His testimony is expected to clarify the chain of authorization for the evidence tampering documented in Exhibit D. She looked at Amara. Ms. Langston, the DOJ's complaint references a pattern or practice investigation. What is the scope? The investigation covers judicial conduct, law enforcement practices, and administrative procedures in the Hinds County Judicial District over the past 3 years, Your Honor. The statistical analysis I compiled, 340 cases, identifies significant disparities in bail, continuance, and sentencing outcomes correlated with defendant race. The department is requesting appointment of a federal monitor for an interim period of 18 months to oversee docket management, bail decisions, and evidence handling procedures. And the court's response to that request? That's a matter for the district court, Your Honor. The complaint has been filed. The process will follow federal civil rights procedure. Hatchett nodded, made a final note. Court is adjourned. The parties will be notified of the scheduling order for the remaining trespassing charge. Ms. Langston, the court appreciates your patience. The gavel came down, not like Braxton's gavel, a weapon, a declaration, a sound designed to silence. Hatchett's gavel was a period at the end of a sentence, functional, final, unremarkable. The courtroom emptied slowly. Marsh packed his files without speaking. Prescott remained at her desk, motionless, staring at the federal complaint she had not yet opened. Booker sat in his chair and looked at the ceiling with the expression of a man whose understanding of his own workplace had just been fundamentally restructured. If this story made you feel something, anger, relief, the slow burn of watching someone stand still while the world tried to break them, then subscribe now, because this channel tells the stories that the system hopes you never hear. Amara collected her exhibits, placed them in the waterproof folder, closed the composition book, walked toward the gallery doors. In the gallery, the spectators, a mix of attorneys, families, and curious courthouse staff who had heard through the building's instantaneous gossip network that something unprecedented was happening in courtroom 3, sat in a silence that vibrated with the particular frequency of people processing information that contradicted everything they had assumed about their daily environment. An attorney in the third row was typing furiously on his phone, A court clerk from another courtroom, who had slipped in during Amara's presentation of exhibits, was pressing her hand against her mouth. An elderly man in the back row, a retiree who attended court proceedings the way other retirees attended matinees, was shaking his head slowly, steadily, as though trying to dislodge a fact that refused to fit into his understanding of the building he had visited every Tuesday for 6 years. At the prosecution table, Marsh was packing his files with the deliberate slowness of a man who understood that the eyes of the courtroom were on him, and that every gesture would be interpreted. His hands were steady, his face was composed, but the folders went into the briefcase in the wrong order, a small disruption in the routine of a man whose routines had been the foundation of his confidence for 2 years, and he did not notice. Prescott had not moved from the clerk's desk. The federal complaint lay 6 inches from her right hand, still sealed, still unread. She would open it later, in the bathroom, behind a locked stall door, where no one could see her face as she read the list of allegations that included the phrase, systematic alteration of docket records by administrative personnel. She would read it 3 times. She would not cry. She would return to the clerk's desk and sit down and stare at her computer screen for 45 minutes without typing a single character. At the clerk's desk, she paused. Prescott did not look up, but Jonah, standing behind Prescott's shoulder at the filing cabinet, raised his eyes. Their gazes met for 1 second. He gave a small nod, the kind of nod that contained no words but carried the weight of 3 weeks of silent observation and 1 unsigned envelope. She returned the nod, walked through the doors, down the hallway, through the metal detector. Calloway was not at his station. He had been informed by courthouse security 40 minutes earlier that a federal investigation was underway and that his interactions with Amara Langston were being reviewed. He had walked to the break room, sat down in a plastic chair, and placed both hands flat on the table, the same table where he had eaten lunch every workday for 7 years, and tried to calculate the distance between where he was and where he was about to be. The calculation did not produce a reassuring number. In the hallway outside courtroom 3, Booker leaned against the wall with his briefcase hanging from one hand and his other hand running through what remained of his hair. He had represented defendants in this courthouse for 11 years. He had watched Braxton deny continuances, inflate bail, and compress trials into time frames that made meaningful defense impossible. He had advised clients to plead no contest because the alternative, fighting, was statistically futile in a courtroom where the judge controlled the outcome and the system protected the judge. He had never, not once in 11 years, considered the possibility that the system itself was the defendant. A young public defender from the office next to his, a woman named Rachel, who had been on the job for 8 months and still believed that the law and the practice of law were the same thing, approached him in the hallway. "Mr. Booker, was that real? A DOJ attorney, undercover, in our courthouse?" Booker looked at her, looked at the closed courtroom doors, looked at his briefcase which contained 47 active case files, each one representing a human being whose outcome in this courthouse had been shaped by a system he had been too overwhelmed, too compromised by caseload and routine to examine. "It was real," he said, "and I think we need to look at our old files." Rachel stared at him. "All of them? Start with the ones Braxton denied continuances on. Pull the bail records. Compare them." She nodded, walked away, already pulling out her phone, already calling the legal aid office, already beginning a process that would keep her and Booker occupied for the next 4 months as they reconstructed the statistical reality that Amara had documented in a composition book they had never been allowed to read. She walked down the limestone steps into the October sunshine and stood on the sidewalk for a full minute, breathing air that smelled like downtown Jackson, diesel and magnolia, and the metallic tang of a city that had been fighting the same battles for longer than she had been alive. Diane Colfer appeared beside her. They did not embrace, did not shake hands. Colfer simply stood beside Amara and looked at the courthouse's limestone columns. "Tran signed the cooperation agreement this morning," Colfer said. "He confirms the instructions came through Meridian's account manager, a woman named Deborah Voss. But Voss resigned from Meridian 3 days ago. Her forwarding address is a P.O. box in Biloxi that hasn't been checked. The money trail? Meridian's payment for the county contract was routed through a local political action committee, Citizens for Judicial Integrity. Registered address, a law office on Capitol Street. The registered agent is Braxton's former clerk. Former. She left the position 8 months ago. The PAC was registered 9 months ago. Colfer paused. It's circumstantial. Not enough for criminal charges. Not yet. But enough for the pattern or practice investigation. More than enough? They stood in silence for a moment. The courthouse behind them continued its daily operations. People entering, people exiting, the metal detector beeping, the elevators humming. The building did not know it was under investigation. Buildings never do. They simply continue to function, processing the people inside them with the indifferent efficiency of systems that have outlasted every individual who has ever tried to change them. 6 weeks later, the motel room on E55 had been vacated. The composition book had been transferred to the DOJ's evidence archive in Washington, cataloged and sealed, its 37 pages of handwritten analysis now part of the official record of the investigation. The waterproof folder was in the same archive. The photographs, the FOIA responses, the equipment status certification, the docket printouts, the gas station USB drive, all of it preserved, labeled, cross-referenced, and waiting for the legal process that would take months to unfold and years to resolve. Braxton was on administrative leave. The Mississippi Commission on Judicial Performance had convened a preliminary review panel that would hear testimony from courthouse staff, attorneys, and defendants over a period of 6 to 12 months. He had not been removed from the bench. He had not been charged with a crime. His pension remained intact. His law license was active. His attorney, a Jackson firm that specialized in defending public officials, the same firm that had represented 3 previous judges before the commission, had filed a motion to quash the federal pattern or practice investigation on the grounds that the DOJ's investigation exceeded its statutory authority. The motion was pending before the district court. No hearing date had been set. Braxton gave a single statement to the Jackson Clarion Ledger. I have served Hinds County with integrity for 22 years. This federal overreach will be addressed through proper legal channels. He did not take questions. His attorney stood beside him, hand on his client's arm, steering him toward a waiting car. Oakley remained suspended without pay. His union, the Hinds County Law Enforcement Officers Association, had filed a grievance contesting the suspension, arguing that the internal investigation had been tainted by federal interference, and that Oakley's due process rights had been violated. The grievance was under review by an arbitrator selected from a panel that included 2 former officers and 1 civilian, a structure that, historically, produced reinstatement in 67% of contested suspensions. The hit and run remained an open case. The partial plate from the gas station footage had been submitted to the Mississippi Crime Lab for enhancement, but the results were pending. The county motor pool's vehicle log for October 14th showed an entry that read, "Administrative error, records incomplete for the requested date." The 10 minutes of missing body cam footage from the night of the accident, a gap that mirrored the 4-minute gap from Amara's arrest, remained unexplained. Marsh had been referred to the Mississippi Bar's Committee on Professional Responsibility. The referral cited the filing of the interference charge under Section 97-9-73 without factual basis, and the document dump tactic that had buried the equipment status certification on page 147 of a 200-page discovery packet. No hearing date had been set. Marsh continued to practice law in an adjacent county, where he had been reassigned pending the investigation. His cases in Braxton's courtroom had been redistributed. Tran had signed his cooperation agreement. His testimony confirmed the technical details, the metadata modifications, the CCTV purge commands, the IP addresses and timestamps, but could not identify the person who had authorized the contract. His instructions had come through Deborah Voss, the Meridian account manager, who had resigned before being deposed. A federal subpoena for Voss's testimony had been issued. She had not been located. Her last known address, the P.O. Box in Biloxi, showed no activity since October 28th. Tran himself had cooperated fully. A 29-year-old ET specialist who had understood, within 48 hours of receiving the DOJ's initial contact, that the routine database maintenance he had performed was not routine, and that his choices were cooperation or prosecution under 18 U.S.C. Section 1519. destruction and alteration of records in a federal investigation, carrying a maximum sentence of 20 years. He chose cooperation. He provided server logs, email chains, encrypted communication records, and a detailed technical narrative of every modification he had made to the Hinds County Courthouse's digital infrastructure. His testimony established the following. Between October 9th and October 23rd, he had modified the metadata timestamps on 4 body cam files, purged 17 days of CCTV backup footage from the courthouse's security server, and altered the digital filing timestamps on 11 docket entries, 3 of which were in Amara's case, 8 of which were in cases involving other defendants whose names he did not know, and whose files he did not read. 11 entries, not 3. 8 additional cases that Amara's investigation had not yet identified. When the DOJ's forensic team asked Tran why he had not questioned the scope of the modifications, 17 days of footage purged, 11 docket entries altered, his answer was a single sentence that would appear in the Federal Monitor's first quarterly report. I was told it was a system migration. I didn't think about it. He was not a villain. He was infrastructure. And the people who had used him, the people who had placed a contract through a third-party firm, communicated through encrypted channels, and paid within 48 hours to avoid the paper trail that slow payment would create, had counted on exactly that. They had counted on a man who was good at his job and bad at asking questions. The question they had not asked was whether the DOJ was already watching. Calloway had been reassigned to desk duty on October 28th, the day after the courtroom reveal. His new position was in the basement records room of the Hinds County Administrative Building, a windowless space that smelled like old paper and institutional regret. He processed archived files for 8 hours a day, alone, with no public contact and no access to the courthouse where he had spent 9 years defining the physical boundaries of who belonged and who didn't. His union had not filed a grievance on his behalf. The distinction was notable. The Hinds County Law Enforcement Officers Association had filed for Oakley within 72 hours. For Calloway, a bailiff rather than a sworn deputy, the union's calculus was different. Bailiffs were expendable. Deputies were not. The union's resources were finite, and the political cost of defending a man, caught on 3 separate occasions, putting his hands on a federal attorney, exceeded the political benefit of protecting a member. Calloway sat in the basement and processed files and thought about the woman whose arm he had gripped, whose wound he had tapped, whose body he had pushed into a wall over a pen that was not hers. He thought about the 6 seconds he had held her arm on October 10th, the 3-second grip on October 15th, the half-second brush on October 17th. Each contact documented. Each contact time-stamped. Each contact now part of a federal record that would follow him for the rest of his career, however long that career turned out to be. The courthouse itself had been placed under interim federal monitoring. A DOJ-appointed monitor, a retired federal judge from the Fifth Circuit named Harold Simmons, would oversee docket management, bail decisions, continuance rulings, and evidence handling procedures for a period of 18 months. His first report was due in 90 days. The monitor's appointment had been contested by the Hinds County Board of Supervisors, which argued that the county's judicial system was functioning within acceptable parameters, and that federal oversight was an unprecedented intrusion into state sovereignty. The contest was pending. Amara returned to the courthouse one final time on a Tuesday morning in early December. The cut above her eye had healed into a thin scar, a line of slightly paler skin that she could feel when she closed her eyes, a permanent record written on her body by the county that had tried to break her. Her ribs no longer ached. The bruises on her arm, Calloway's fingerprints, faded now to yellow-green smudges, had disappeared entirely. She entered through the front door. The metal detector beeped. A new bailiff, young, unfamiliar, hired after Calloway had been reassigned to desk duty pending the federal review, waved her through without comment. She walked to the clerk's window on the second floor. The window was staffed by a woman she did not recognize. Prescott had been placed on administrative leave the previous week after the docket timestamp discrepancies identified in Jonah's printouts were confirmed by the federal monitor's preliminary audit. Behind the new clerk, at the filing cabinet in the corner, Jonah Wyatt stood in his usual position. Same posture, same quiet, same mechanical efficiency that disguised the attention he had been paying for 3 weeks. Attention that had produced 3 printouts, 1 unsigned envelope, and the single most important piece of evidence in the case. Their eyes met across the counter. He gave the same small nod, barely perceptible, the smallest possible gesture of recognition between 2 people who had occupied the same building for 22 days and had spoken exactly 2 words to each other. She returned the nod, turned to leave. "Ms. Langston." She stopped, turned back. It was the second time he had spoken her name. His voice was quiet, the voice of a man who had built his entire professional identity on silence and was spending that silence now, word by careful word, like a currency he could not replenish. He held up a single sheet of paper. "You left this in the filing tray." She took the paper. It was blank. Standard courthouse letterhead, the kind stacked in every tray on every floor. She turned it over. Nothing, but folded inside, creased along the paper's center, invisible until she opened it, was a handwritten note. Block letters. Careful, deliberate. 6 lines, each one a case number. 6 cases she had not found in her own review. 6 defendants whose docket entries showed the same timestamp irregularities. 6 more files that would need to be pulled, analyzed, cross-referenced. 6 more names attached to 6 more stories of a system that had been quietly adjusting its records to ensure that certain people who looked like Amara, people who looked like the 340 defendants in her statistical analysis, received outcomes that the law did not intend and the Constitution did not permit. She folded the note, placed it in her pocket, looked at Jonah. "Thank you," she said. He returned to his filing, said nothing more, but his back was a little straighter than it had been, his movements a little less mechanical, the posture of a man who had done something, one small, anonymous, dangerous thing, and who was still standing. She walked through the hallway, past the break room where Prescott had spread gossip that poisoned her first week, past the water fountain where she had overheard the fabricated narrative about photographing the building, past the elevator where she had stood alone each morning, counting floors, counting exits, counting the days until the composition book in her pocket would transform from a notebook into a weapon. The limestone steps outside were cold in the December air. She descended them the way she had ascended them 22 days earlier, one at a time, each step measured, each step deliberate. But the weight was different now. The backpack was lighter, the folder was in Washington, the composition book was in evidence. She carried nothing that mattered except the 6 case numbers in her pocket and the scar above her eye. At the bottom of the steps, she paused, turned around, looked at the courthouse one last time. Limestone columns, wide entrance. The words Hinds County Courthouse carved into the lintel in letters that had been there for 90 years and would be there for 90 more, regardless of who sat behind the bench or who stood at the security desk or who filed papers at the clerk's window. The building would outlast all of them. The building would outlast the investigation, the monitor, the reforms, and the people who had fought for them. That was the truth about institutional change. The institutions survived the changes the way rivers survive floods. The water rose, receded, and the riverbed remained. But riverbeds could be reshaped, slowly, incrementally, by the persistent pressure of water that refused to stop flowing. Amara walked to the rental car, across the parking lot to a rental car. The Nissan had been impounded as evidence. The paint transfer on the bumper was now Exhibit B in the federal investigation's growing file. She drove south on I-55, through the flat Mississippi landscape that stretched to the horizon in every direction, cotton fields and pine stands and the occasional billboard advertising injury lawyers and used cars and a better life somewhere else. The radio was off. The windows were up. The only sound was the engine and the hum of tires on interstate asphalt. Her phone buzzed. A text from Diane Colfer. 6 new case numbers received, expanding scope. Preliminary audit confirms pattern extends beyond Braxton's courtroom to 2 additional judges in the district. This isn't over. Amara set the phone on the passenger seat, watched the mile markers pass, did not smile, did not celebrate, did not feel the triumphant rush that movies assign to moments of justice achieved. Because justice had not been achieved, justice had been initiated. The difference was the difference between striking a match and building a fire. One was a moment, the other was a process that required constant attention, constant fuel, and the understanding that the wind could change direction at any time. Braxton was on leave, not removed, not charged, not accountable, not yet, not in any way that would survive the motion to quash that his attorney had filed, with the confidence of a man who had won 60% of his cases against federal oversight. Oakley was suspended, not fired, not prosecuted. His union was fighting for reinstatement with the institutional persistence of an organization that had never met a suspension it wouldn't challenge. Marsh was practicing law in the next county. Prescott was on leave. Calloway was at a desk. Voss was missing. Tran was cooperating. The motor pool records were incomplete. The body cam footage was still missing. The system had bent. It had not broken. And the people inside it, the people who had built it, maintained it, benefited from it, defended it, were already beginning the process of straightening it back into its original shape. Because that is what systems do. They resist change the way water resists being pushed uphill, not through force, but through the patient, gravitational persistence of returning to the shape that requires the least effort. But the folder was in Washington. The composition book was in evidence. The statistical analysis was in the federal monitor's hands. And 6 new case numbers, written in careful block letters by a 24-year-old clerk who had never raised his voice in 3 years of courthouse employment, were about to extend the investigation into territory that Braxton, Oakley, Marsh, and the entire Hinds County judicial apparatus had not anticipated. The Mississippi flatlands scrolled past the rental car's windows, pine trees, power lines, a sky the color of old paper. Amara drove north, toward Washington, toward the next case, the next courthouse, the next building full of people who believed their authority was absolute, and their records were permanent, and their version of justice was the only one that mattered. She had been wrong about one thing. She had told Booker that what would happen in the courtroom was partial justice, the kind that takes months to finish and years to feel. She had understated it. It would take longer than months, longer than years. It would take the kind of patience that most people could not sustain, and most systems were designed to outlast. But the match was struck. The file was open. The process was underway. And 3 weeks after she left Jackson, a packet arrived at the DOJ's Washington office. No return address, no postmark, just a courier stamp from Jackson, Mississippi. Inside was a single USB drive and a handwritten note in careful block letters. There are more.
Thank you for taking the time to watch this video today. If you found the content helpful, please remember to like and subscribe so you won't miss our upcoming episodes. If you have any questions or suggestions, feel free to leave a comment below. We are always here to listen.